without any specification. They said only to act in accordance with law. Competent authority is at page 126.
Directed to administer the association in accordance with law.
That's all.
In view of the complaint lodged by Sri Manoj Agarwal and Sri Neha Agarwal. You stated they are claiming 30% more. 30% more of 30% of which?
Of the charges for maintenance charges and other charges. Using of swimming pool amenities.
How much? 30% would be?
My client has already paid 53,078 and 62,037.
53,000 and odds.
53, one is 153,070 and another is 62,037.
You have two flats.
Two flats.
53,037.
37 and 62,037.
And
97.
50% would be around 15,000. So 15,000, 30,000 is the matter. Okay, I am sending you to the mediation.
Let me take instruction in that. Can I keep it on tomorrow? I will take.
Yes, I am sending the mediation
tomorrow.
Because it is a problem in between yourself and the association. Now you have implicated the original authority and appellate authority under West Bengal Apartment Ownership Act. Right. Now the appellate authority says, have you brought the book?
I have not brought the book, but I have the printer.
10A.
10A.
10A. You saw the 10A within bracket 3 of the Act. For 30,000, you are giving problem to the High Court.
Clients is like this is said any person aggrieved by an order of rejection under subsection 2 may appeal to such appellate authority as the state may by notification in the official gazette appoint, provided that such appeal shall be made within 30 days from the date of such order or within such further period as the appellate authority may allow or sufficient grounds being shown in this behalf. The order of the appellate authority on any such appeal shall be final and shall not be called in question in any court.
So appeal, the statutes has make a provision for appeal.
Yes, my lord.
Against an order of rejection under section 2.
My lord.
Now what 2 says? On receipt of subsection 2, on receipt of a declaration or amendment made thereto, or an instrument under subsection 1, the competent authority shall examine the declaration amendment as the claimant to ascertain whether the comparable declaration by giving. So it is in respect of an instrument. Any declaration referred to say or amendment shall. What declaration? So section 2 says any declaration by the owner. So it will not come under the purview of section 10A. Appellate authority has rightly stated.
So far the original authority is concerned, you will kindly see the order. And what is my complaint?
what is the function of a competent authority or appellate authority regarding maintenance charge?
Not only maintenance.
You show or satisfy the court that regarding illegal fixation or demand of excessive amount towards maintenance charge, the competent authority and appellate authority can interfere.
Give me 1 minute.
It is the association has fixed the charge.
An association, my question is that
Have you brought the entire book?
I have not brought the entire book. I have brought the printout. You can
There is a rule most probably in an apartment. What would be the entire maintenance cost that would be assessed, and thereafter it would be divided and proportionately, and a person holding a apartment shall be bound to pay the proportionate share.
I am ready to my client's instruct.
Share. Okay. So that dispute whether the competent come within the purview of section 10A or not, and whether the competent authority and appellate authority has a jurisdiction to apply their office, good office, to decide such issue or not. So I am keeping under the heading hearing.
There is a motion, my lord. Your lord, can you keep it on Monday? I will satisfy. If not, your lord.
It is motion.
Motion stage. It's a motion stage, my lord.
That is the first time, my lord. There is no direction at all, my lord.
Okay, I mean not this week. You find out there is
I will.
Rule is that
I will.
That entire maintenance cost, electricity cost, and salary, common area service, salary of the security, all would be calculated. Then that would be divided by equal share, and that the apartment holder or owners of a particular apartment shall be bound to pay
What happened in this
proportionate share.
What happened in this case? They have initially provided the facilities. Thereafter, I referred the matter to the arbitration. Since the deed of conveyance was not executed, there are some lacuna. Ultimately, I succeeded in the arbitration. Now they are rectifying their defects, and thereafter draft deed of sale has been forwarded to my client. Then they are going to register the same. In the meantime, what happened? They have discontinued the service since I have preferred the arbitration. They have discontinued the service. Now I said, when you have discontinued the sale, I would not pay the interest. They are claiming that you have to pay the interest, otherwise the service will not be restored back. Ultimately, I have paid the original amount.
Have you brought your deed?
I have brought the deed, draft deed. So registration has not yet been done.
Registration
has not yet
any agreement?
No, there is no such agreement. Only allotment order is page 23. And there is
so you are not owner. There must be some agreement. There must be some.
They have sent me the draft deed, which I have.
You find out what is their bylaws, such and such. You try to find out. And ownership apartment act. Now I cannot recollect. You find there is a rule.
Obviously, my lord.
Rule 20. Whether there is a section 20.
No, there is no section 20.
There is no section 20.
There is a rule para.
So you find out the rule. Okay. The rule. Yes.
Grateful, man.
Item number 2.
Item number 2. You come in.
Sorry. At last, Mr. Mukherjee is here today, my lord. Right to education. 2000, may I place the facts, my lord?
Yes.
My lord, 2004, a notification was issued for recruitment of para teacher.
What?
For recruitment of para teacher.
Yes.
Thereafter, due to pending litigations, the recruitment of para-teacher was stayed in all over state of West Bengal. And ultimately, it was finalized. A panel was prepared in the 2010. Appointment was given. Petitioner was working
Appointment in 2010.
from 2010. 2015, government, December 2015, government of West Bengal issued a notification that the teachers who is not possessing training qualification, they have to obtain the training qualification in terms of the NCT guide notification.
Even for
Uh,
charity
for
teacher
para
also.
teachers also. Now, I applied. When I applied, the authority said, since your service has not been confirmed up to the age of 60 years, we cannot proceed. Then I made application before the district project officer that kindly confirm my service so that my service has been confirmed up to the age of 16 years, up to 60 years. Well, 2010, government issued a further notification that the para teachers who are engaged, they need not renew their service. They will be engaged up to the age of 60 years. One-time renewal. That was not done in my case. Then I applied. Now, without granting such confirmation, they asked me, since your service has not been extended up to after 2010, your service is illegal. 2016, they are saying so. I challenge such decision. This Honorable Court passed an order. Malad, kindly see what was the order.
Page 53.
Page 17, my lord, first order.
17.
Yes, my lord, 17. No, sorry, my lord. Page 27. Landed Council appears for the petitioner submits that the pursuant to the order passed by the Honorable Single Bench, the petitioner was engaged as additional para-teacher for teaching in upper primary section of the school in issuance of on a consolidated pay. The engagement of the petitioner was renewed from year to year till the School Education Department, Primary Branch, Government of West Bengal introduced a circular dated 22nd July 2010, by which the para-teachers who are already engaged were directed to continue till attaining the age of 60 years of age without any further renewal in their service. Sri Sahara submits that the present writ petition is directed against the inaction on the part of the Paschim Banga Sarva Shiksha Mission represented by the number 416. This petition is not issuing the letter of engagement in favor of the present petitioner, indicating the terms of his present engagement so that the petitioner can avail the online registration for pursuing a 2 years DLED course for service para teachers conducted by the West Bengal Board of Primary Education. The state respondents are represented such and such. Having heard the parties, the considering the matters on record, this court grants leave to the petitioner to file a comprehensive representation before the respondent number 7 within the course of 13 January 2016, and the respondent 7 is consulted with the respondent 1 shall take necessary steps in this regard. The petitioner shall be intimated in the decision taken by the respondent 7 within 2 years such and such. This was made. I made representation. This is my detailed representation.
Yes.
Thereafter, they took a decision. On page 33. 9.
Yes.
In compliance with the solemn order of the Honorable Justice Subrata Arugdar Pajan Path, the petitioner noted under subject written, it's not difficult to read. It's not very difficult to read. The last through line is not considered for continuation as a para teacher in the said school. Consequently, he is not eligible for online registration for DLED. Last 2 lines of the first paragraph. Lordship got Malat? For certain reasons, the matter is also confirmed by the district level committee in their meeting held on such and such. The additional estimate such. Not I have challenged the same. On the next page is the order. The contention of the authority was set aside by this honorable court with certain observation.
Yes,
There are
you
these-
challenge this
yes,
order.
Page 34 is the order.
Uh,
Operating part is page 35. Having heard the parties and having considered the materials and the aforesaid circular, there can be no reason for the authority to hold that the petitioner should be discontinued from her service once she was duly engaged as a para-teacher, particularly when it is mentioned in those circular that fresh renewal is not necessary. In the ad view of the matter, the order impute passed by the project officer is set aside, and the said authority is directed to pass a fresh reason order after giving an opportunity of hearing to the petitioner, and the petitioner will be entitled to rely on documents in favor of claim as para-teacher within a period of 4 weeks from the date of communication of the order after taking into consideration of the above mentioned circulars, and also to take a decision whether the petitioner was duly engaged on 13th May 2010 as a para-teacher of the school. In the event it is found that she was duly engaged as a para-teacher, she will be allowed to online registration without any delay. The said respondent is also directed to communicate these decisions. This was. Thereafter, they took a further decision.
Yes.
Page 37. After perusing the documents related to these two writ petitions and verbal submission of the persons present at the time of hearing in the present, it is seen that the 6 posts of para-teachers were sanctioned in favor of Muldia, such with the
Such and such, by memo number, such and such.
3 posts are reserved for female only. Due to violation of the reservation policy, Sarvasya Commission, the panel was cancelled by the district authority in 2004. In compliance with the solemn order, this is such and such. Although an embargo was issued for appointment of para-teacher in 2010 by the School Education Department, the school authority issued engagement letter to the petitioners on 23/9/2010 with validity of 1 year only. In absence of with the memo number such and such dated 2010 of DPO Assistant Rantupargona. In accordance with the engagement letter of the school authority, both the candidates, that is Pompa Haldar and Iqbal Hossain Gaji, the present petitioners joined in the school as para-teacher on 4th October 2010 at Muldia Chaitanyapur Vidya Mandir. The engagement of para-teachers of Muldia Chaitanyapur Mandir was not considered by the district level committee in their meeting held on 11/2/2016. And their salary was stopped from February 2016, which was also duly communicated to the concerned persons. Order. In the present two cases, the Honorable Justice was directed the undersigned to take a decision whether the petitioner were duly engaged on 13/5/2010 as para-teachers of the school or not. From the submitted papers, it is crystal clear that both the petitioner joined at Muldia Chaitanyapur school on 4th October 2010. So the petitioners were not duly engaged on 13/5/2010 as para-teacher as Muldia Chaitanyapur. So this was the only observation, nothing else. Since on a particular date we have joined, they said they are not. Again, it was challenged. The court, next page 39. Relevant part, may I read from page 40?
Page 39.
39 starts, relevant portion, page 40.
Again, that order
Yes.
was challenged.
The impugned order was passed pursuant to the direction of this honorable court in its order dated 10th November 2016. Hence, I cannot say that the impugned order is perverse as it decided the facts referred to DPO by the court. However, it is also true that the aforesaid division bench order of the circular dated 6th November 2000 were not considered by the DPO, perhaps because the same were not placed before him. Accordingly, I remand the matter back to the DPO of SSM South 20 Pargana, being the respondent number 4, for taking a fresh decision in the matter in the light of the all relevant circular notification, including the circular dated 16 November 2010, as also the division bench order dated 13th October 2015 referred to above passed in Memeti such and such. The DPO shall give a hearing to petitioner and another authorized representative who shall be entitled to place the relevant documents, including a notification such and such. The decision shall be supported by reasons and shall be taken within a period of 4 weeks from the date of communication of this order. This was the order. During the hearing, I relied on this judgment. Next page, page 42.
Yes.
This judgment of the division bench.
Judgment of the division
Division
bench, 13 13/10/2015.
2015.
Yes, what is,
Considering this judgment was not considered, since the court directed to consider this judgment while deciding the
yes,
decision.
yes.
Well, they take a
What is the position or what is the order of the
this
division?
order has said, in 2010, the government issued a notification, one perhaps April and one perhaps May or June, that no new engagement of para teacher from this date. Firstly, my case is not at all new. It was a selection process of
It is
2004.
nothing but a re-engagement.
2004 it was initiated due to court's order. It was postponed. Ultimately, I was selected even before the cut-off date also selected. Even before cut-off date, my appointment was given. However, this court observed that delay occurred on the part of the authority, not on the fault of the petitioner. For that ground, the petitioner's claim cannot be rejected. This court observed. If the authority ought to have taken the appropriate steps at the appropriate time, then the appointment would be proper and appropriate. So, for that reason, the candidates cannot be
Forced to suffer.
yes.
Okay, they pass, then again they pass.
47, page 47, further order.
What ultimately they held?
Order, on page 48. last
48,
portion.
yes.
After hearing all concerned and peruse the relevant papers, I am of the opinion that since the petitioner joined as para-teacher after 1/6/2010 and her engagement was issued for 1 year only, so in accordance with the above noted government order, resolution, etc., I am not in a position to give her any relief in her reinstatement as a para-teacher. Again, almost similar order, my lord. Again, this was challenged, my lord, again. Page 53.
Coming, I am coming. Yes,
Page 53.
page 53.
Yes, ma'am.
Again you have challenge.
Yes.
53, Justice Boswell.
But it requires detailed ballot. May I read, my lord?
Petitioner was granted liberty to make an application for getting benefit of the government order dated 16 November 2010.
Now, before that last paragraph, my lord,
Yes.
3 lines. Rejection of prayer of the petitioner without considering the apportionment and government order is not justified. As such, the order imputed is set aside. That government order, which government order? My lord, kindly see. That is at page 49.
2010.
Page 49. 16/11/2010. Page 49. I have annexed that government order. They said after June 2010, there will be no new engagement.
Yes.
First of all, my appointment was not new engagement. Secondly, this circular kindly see, the government had sometime been examining the present process of engagement of para-teacher, VRP and Shiksha Bandhu under Shiksha Sarva Shiksha Abhiyan as serious complaints are received about the present system of yearly renewal of contract by the school management committee and the actual code of work and the performance of the para-teacher. VRP, Shiksha Bandhu. Further, in terms of the financial observation under such a para-teachers and Shiksha Bandhu also need to be engaged directly by the district project officer. This line clearly said that there was no bar to engage new para-teacher. After careful consideration of the matter, it has now decided that all para-teachers, VIP, Shiksha Bandhu will now be engaged by the district project officer. So, June 2020, there was no bar of engagement. Even 2011, they himself issued this circular. That they have changed the process.
From school to district project office.
Yes, this one. This was not considered. That's why the court directed to consider this circular. and also the judgment. Only thereafter, they ultimately allowed me to join. Page 58, my joining letter.
They've allowed to join.
Yes.
Yes.
After the 4 read petition.
Yes. Now what is the problem? They are not allowing you
Now-
to make online registration.
Yes, Malad. Two things, Malad, my twofold prayer. I am entitled some area salary that has not been given.
You went on serving, rendering your service.
Yes, I tried to serve, but they restrained me from performing my duty. They never issued any order of termination. They cannot let them show a single letter that they have terminated my service. They never terminated my service. They just restrained me from performing my duty.
So you have not performed any duties.
Yes, well, I admitted fact. But some period I have performed. Well, that salary, that period I
Now,
am.
whether they have now stated that they will extend the benefit of 16 November
Yes, that has not been
2010.
granted. That's why my read petition.
Oh,
Whole prayer, that area salary and for particular period from February 2016 to 5th September 2016, few months, I worked till 5th September 2016. From 6th, they restrained me for performing my duty. That period salary I have not received, but they have not, and my confirmation of service so that I can obtain my training. That is my only prayer.
Thank you.
yes. Who will say Mr. Mukherjee?
Yes, kindly say page 55. Middle portion, third paragraph. Have you also got it?
Yes.
Comment order bearing number 376 AC dated 9 June, they prescribed no new engagement of para teacher or any category of this can be made after issuance of this order. This is the 9th June 2010 order. This said this is page 12 of the affidavit in opposition filed by the kindly see that page 12 of the affidavit affirmed by the Resmita Chattopadhyay. Kindly see opposition, affidavit in opposition affirmed by Devasmita Chattopadhyay. Page 12, paragraph 2.
Yes. Oh, page 12 of?
Page 12 of the affidavit affirmed by, on behalf of the respondent number 2.
Yes, page 12.
Page 12, have got it? Why this has been, there is a history, but there is a logic behind it.
Yes.
No new engagement of para teacher or any other category of employee can be made after issue of this order. That means after 9th June 2010, no para teacher can be appointed.
No new para teacher.
No new engagement. Just time. No new engagement of para teacher or
They
any
have
other
deliberately avoided the word new in their report, Malad. Deliberately avoided the word.
Why this has been done? Your Lordship knows that Right of Children and Free and Compulsory Education Act 2009 came into force from 1st April 2010. Section 23 provides that what should be the qualification. Kindly see section 23. Section 23 of the Act empowered the NCT to prescribe the qualification for appointment of teacher in a up to class 8 standard. That means right to get education up to the age of 14 years. That means class 8 from 1 to 8. He must
23, so teacher, whether para teacher, 23 has.
no teacher. Para teacher also a teacher.
What it said?
Okay, so teacher includes para teacher, you show that
Without the training.
provision.
Without
say-
these
Without the training.
without training.
No, a para teacher,
How
a
2016
para
recruitment
teacher.
process in primary school conducted by the primary board without the training qualification. 32,000 candidates they have given appointment without the training qualification. 32,000 candidates they have given appointment. 2018. 2016 recruitment process, and 2016-18 they have given appointment. 32,000 teacher, not one, without the training.
And according to this notification issued by the same
So the argument in between you and Mr. Bari has not yet been concluded. So you conclude it. I have adjourned the matter for 7 days. You go bar
No,
to the bar,
Sir,
conclude the argument,
Actually,
then come to the court.
this enactment.
No, so you are showing that right of children, right to education, Education Act 2009.
And came into force 1st April 2010.
Yes, a para teacher would be a teacher
teacher.
within the meaning of that act.
On a-
You just show.
On a teacher, para teacher means they will teach the students. They may be may not be the full-time teacher. They not be appointed by the School Service Commission or by the Primary Board of Education. But they must have minimum qualification. Namely, diploma in elementary education, must have 50% marks in a higher secondary or school for 10th class examination, and then they will be appointed by either by the board or by the banking committee or by the district level team. This is the minimum qualification. Para teacher means is someone who assists to full-time licensed teachers or the classroom, but is only fully certified as a teacher themselves. The specific role can vary country due to education share, but there are some common characteristics. Supporting the main teacher with the instruction task, helping the students with learning difficulties or difficulties, assisting with the classroom management, providing one small group tutoring, supervising students in the absence of the male teacher.
What from you are reading?
Now, para teacher means
Para teacher means from where?
from the from the site. But there has been dictionary meaning of that.
11 part গুলো বলুন না,
Just for now, my lord,
From the teachings of Google.
teaching so.
Oh.
Kindly see the imprint order, page 62. Page 62. I'm not disturbing your lordships. Opinion.
I passed in this judgment in this. Sahana Parvin. The matter went up to the Supreme Court most probably. Supreme Court or division bench.
But what was your lordship's
Up to the division bench, it has been
what
apart.
is your lordship's observation, Manan?
That cut-off date should not be applied to the ongoing proceedings
Yes.
or
Yes, well, it is
cannot be
well-settled law.
given to retrospective
That is a well-settled law.
to appear. Yes.
That is a well-settled law, Manan.
কি বলেছেন?
Adopted legislation process that was initiated prior to the cut-off date. Extended to the candidate.
Then one kindly see heard the submissions of the persons attended and scrutiny of official documents. I have the opinion that in spite of receiving the memo number such and such dated 4th March 2016, attendance of Srimati Pampa Haldar till 5th September purely arbitrary and against the letter and spirit of the said memo, as the memo was issued on 4th March 2016 and communication thereafter. It is being ordered to disburse the remaining 2 months remuneration from 15th February 2016 to March 2016. Regarding confirmation of service at age of 60 years, matter is considered subject to the outcome of the mat number pending before the Honorable High Court of Calcutta. Kindly see the order of the
Order of
appeal court. Mat number 425. Order of the appeal court. Mat number.
yes.
You know that in spite of the order, thus he was not allowed to join till till 18 December 20 in order 7th, the authorities concerned were directed to allow the petitioner to join immediately within 10 days from the date the pendency of the appeal was shown as a cause for not allowing the petitioner to join duties. As such, we are of the opinion that the petitioner should be entitled to salary from February 2020, just for the same order, 16 February to March 2016. No 60 years, but only that period have been directed to pay salary to be paid.
What my learned city is trying to establish by showing this judgment, it is in my favor. The director to release my salary, area salary also.
No.
That is also my prayer here. Is supporting my case.
Yes.
The district project officer that February 2016 to March 2016 there should be paid.
Hmm.
But the same thing said from February to the 20 to November 20. But subject to decision of the appeal, this order was passed. The appeal court said that quoted that 16 February to March 2016 we are ready to pay.
16 February.
Page 63. It is ordered that disburse the remaining 2 months remuneration from February 2016 to March 2016.
March.
Regarding
I performed till 5th September 2016. Did they produce my attendance register?
then attendance register has to be put in before the civil court, not before the high court.
Why civil court?
What notional benefit you want? Whether any scope of granting notional benefit?
That I can't say. They can say whether for the parateachers there is any provision of national benefit or not. That they can say.
Those who are appointed
But
prior to
in-
2010,
In the exception, they have annexed my attendance register. As per direction of the court, they
Yes,
filed an
yes.
exception. In the exception,
Yes, Mr.
in the exception,
Jai
they have
Yes.
annexed my attendance register.
সমস্যার এপিডিবি দেবেন এটা
হ্যাঁ।
আমার এপিডিবি
হ্যাঁ।
এইটা proof of any notional benefit my lord, for the para teachers.
Yes.
Now my lord, from the impugned order my lord, that is at page 62, which is the reasoned order passed by the district project officer my lord, your lordship will find that 2 issues were raised. The first issue was that arrear salary from February to September, and second is my lord, continuation up to the age of 60 years. Now my lord, your lordship will find that the last 4 lines of page 62, the kindly consider my lord, the last 5 lines my lord. This is under challenge my lord. Page 62.
Yes.
Heard the submissions of the persons attended, and on scrutiny of official documents, I have the opinion that in spite of the receiving the memo number such and such dated 4th March 2016, that is at page 33, my lord, I shall once again place, my learned friend has already placed, the attendance of Srimati Pompa Halda till 5th September is purely arbitrary and against the letter and spirit of the said memo. As the memo was issued on 4th March 2016 and communicated thereafter, it is being ordered to disburse the remaining 2 months remuneration, that is February 2016 and March 2016. Mal, kindly pause here for a moment. Mal, by this order dated 4th March 2016, her case was terminated.
Let them show.
No, I shall show. Certainly, I shall show. My lord, it was terminated. Thereafter, challenge. What happened, my lord? Thereafter, I shall place, my lord, once again. Then, my lord, kindly consider page 63, the last 2 lines, my lord.
Yes.
Regarding confirmation of service till attaining the age of 60 years, the matter is under consideration, subject to final outcome of MAT 425 of 2020 and MAT 426 2020 pending before the Honorable High Court at Calcutta. My lord, I shall address this issue, my lord, later on, my lord. Kindly, my lord, allow me to address on the first issue, that is the arrear salary. My lord, kindly consider page 33.
33.
Yes, my lord.
Yes.
My lord, my lord, it's bit ineligible. My lord, kindly consider, my lord, last 3 lines of first paragraph. The undersigned has to inform, my lord, in the middle.
Got it, got it. Yeah.
The undersigned has to inform him that his such and such of engagement as a para teacher at such and such Vidya Mandir, district South 25 Organs is not considered for continuation as a para teacher in the said school. Consequently, he is not eligible for online registration for DLA.
That order has been
Set aside.
set aside.
My lord, that was
So
set
you
aside.
cannot rely upon.
My lord, it was my lord, communicated, my lord, your lordship will find serial number 4. It was communicated to her. Now this was challenged. On the date, my lord, the service was terminated. This was challenged. Then the order was quashed. This honorable court, my lord, directed the DPO to consider once again. Now that is, my lord, at page 37. There, my lord, your lordship kindly consider last 4 lines. Page 37, in the present 2 cases, the Honorable Justice has directed the undersigned to take a decision whether the petitioners were duly engaged on 13th May 2020 as para-teachers of the school or not. From the submitted papers, it is crystal clear that both the petitioners joined at Muldia such and such Vidya Mandir as para-teachers on 4th October 2010. So the petitioners were not duly engaged on 13th May 2010 as para-teachers and Muldia Vidya Mandir. Now this issue was decided pursuant to an order of this court. This was again challenged, my lord. Then page 39, your lordship will find the order passed in connection with that writ petition 19 July 2017. Kindly consider page 40, my lord.
Yes.
The impugned order was passed pursuant to the direction of this court in its order dated 10th November 2016, passed in such and such. Hence, I cannot say the impugned order is perverse, as it decided the fact referred to the DPO by this court. However, it is also true that the aforesaid division bench order and the circular dated 16 November 2010 were not considered by the DPO, perhaps because the same were not placed before him. Then again, it was remanded. The question is, my lord, that when the initial order was passed, his service was terminated. This subsequent order, my lord, court found that this is not a perverse order. This order has not been quashed even. Now the question is, my lord, whether she worked, my lord, from March to September or not. The authority, my lord, passed an order of termination. He continued till March. That is why, my lord, the authority, my lord, allowed her to draw salary for February and March. Therefore, my lord, from March onwards, my lord, she was not supposed to discharge any duties in view of the termination order, my lord. This is the contention of the DPO, my lord. Your lordship will find from page 62. Therefore, my lord, so far this first portion is concerned, my lord, my respectful submission before your lordship is, my lord, that there is no infirmity, my lord. The second part is, my lord, that the DPO, my lord, was DPO observed that since the 2 appeals are pending, my lord, therefore, my lord, whether he is entitled to get the benefit of 60 years or not, my lord, that will be decided subject to result of this. My lord, these 2 appeals were, my lord, finally disposed of. The Honorable Division Bench, my lord, directed the State Project Director, my lord, to consider this issue. My lord, if I am not wrong, sir, we ordered the Division Bench.
425 I have got, 426 I have not.
Yes, both were disposed of, my lord, in view of the order passed by the State Project Director. There is another order, my lord. My lord, before that, there was one order, because I appeared with Mr. Lakshmi Kumar Gupta, my lord, learned senior advocate. Now, the matter was referred to State Project Director. State Project Director, my lord, extended a personal hearing to the petitioner. And, my lord, if I am not wrong, that benefit was given to those petitioners. Now, if the facts and circumstances of this petitioner, my lord, is, my lord, identical, my lord, then she also, my lord, should receive that benefit. Your lordship can, my lord, so far.
So whether here is 426 order, it is?
Yes, this is 426. This is the final order. But
Final.
before that, the division bench, my lord, there is one order whereby, my lord, the Honorable Division Bench was pleased to refer the matter to the SPD. The matter was taken up pursuant to court's order, my lord, by the SPD. And final.
So, Mr. Bari, Mr. Bari, you file a affidavit, a supplementary affidavit, bring that.
Because
to-
the second issue, my lord, subject to your lordship's kind
Not
correction,
only-
my lord, is
Huh?
my lord on
Only one thing, my lord.
Uh,
I will ask my learned friend, Malat, even learned friend said that my service was terminated. Showing Malat, he showed the paragraph, page 33. I will again ask my learning friend, kindly, Malat, go through this line and tell me where is the termination of the petitioner. Kindly, I will ask my learned friend once again. Page 33. Where is the termination of service of the petitioner?
my lord, the engagement as a para teacher is not considered for continuation.
oh, that.
Now, this cannot be, my lord. Your lordship, kindly consider the last 4 lines to inform him
Is not considered
considered for
for
continuation.
continuation.
Yes.
Consequently, he is not eligible to.
Now, he was, my lord,
So
reinstated.
if it is said it is discontinued,
Discontinued.
now the subsequent order, it was challenged.
It was challenged. Then
Court once observed that court was not in a position to hold that the order is perverse.
yes.
That means not based on no evidence. So according to that it cannot be stated that the order is based on no evidence. But court directed to pass a fresh order.
Yes.
The fresh order, effect of the fresh order would be, it would already set aside the earlier one. Although it has not been expressly stated. I am saying, yes, you have passed a very good order. Your writing is very good, but you write afresh.
No, my lord, there is,
Meaning thereby,
my lord, there is
thereby I have rejected the earlier one.
True.
I don't want to take earlier one. So whatever the ultimate, what language has been used, you forget ultimately the earlier order, the order you are showing has impliedly it has been set aside.
But my lord, whether
Eh?
she discharged or not, actually discharged or not, that is a disputed question of fact.
That is the disputed
And
question.
that is why, my
But
lord, and
evidence is
she
there.
is not
My lord,
supposed to
state produced the
discharge in
attendance
view
register.
of the order of
State produced the
termination.
attendance register. In their reply, they have
She was reinstated on a much later date, my lord, pursuant to court's order. Therefore, my lord, on the relevant months, my lord, whether she discharged,
So that can be again remitted to the subject to what Mr. Bari says, that fact, determination of this fact, whether she
these
actually
evidences are required.
actually rendered any service or not during that period. That would be sent to the district project officer.
No, it is
district
on
project
record.
officer.
Not required, your lordship. It is on record. They are affidavit. State produced the affidavit with the attendance register.
Attended register.
Yes, my lord.
So attended register indicates that she rendered service.
Yes, my lord. Till 5th September.
Okay. So you filed a supplementary affidavit. Look how many times we have paid.
Already, those orders only.
Yes, but it is appearing that it is the last order. Most probably it is a
This is the last
modification
order.
of
But he said, my lord, previous.
earlier order.
Yes, there are orders, my lord, keeping the appeal pending, my lord. The issue was referred to the SPD. The SPD, my lord, extended an opportunity of hearing and passed some orders in favor of the appellants. Now, factually, my lord, they are similarly circumstanced or not, that is a different issue. Your lordship can refer the matter to the SPD, my lord, for a consideration, my lord, in the light of those orders. Or, my lord, your lordship can also
No, that whether he will get any area salary or not.
No, area salary,
No,
my lord, that was
That.
not the
But
actual-
you give benefit up to
But that
60
is
years.
the domain of
that is
state.
the second part, my lord.
Second part, you give benefit up to say 60 years.
Yes.
Because of the fact you don't treat it as a fresh appointment. It is a consequential. The litigation was going on. Actually, selection process was initiated in 2004.
My lord.
He rendered service. Thereafter, dispute cropped up. Then dispute came up before this court on several occasions, seeking intervention of this court. This court intervened and asked the authority to decide, send the fact-finding authority to decide. So this, due to this prolonged litigation, one person cannot be suffered. He is not a luxurious litigant. So you give benefit of 60 years. And regarding this fact, this question of fact, whether he is rendered service or not, whether he will get any area salary or not, and if he get, for how many periods he will get, you determine that issue. But give benefit up to 60 years. Eh? So shall I pass this order here and now? Or we shall wait?
Regarding area salary, the documents is on record itself. Malad.
That is a
No, the appeal,
State's
appeal,
affidavit, not mine.
MAT 426.
Malad, that I have to.
Malad,
Malad,
that was restricted to only, my lord, by extending the benefit of 60 years. That arrear salary, my lord, will depend case to case whether
Case to case, yes.
now, my lord, whether she actually discharged or not, that is a disputed question of fact. Your lordship can refer this matter to DPO. Let the DPO, my lord, give an opportunity.
not
of hearing that
required.
adduced
How many
evidence.
times it will
You
refer
can
to the
use this
DPO?
affidavit, my lord, before the DPO, that this affidavit
Is
was
there-
used before this honorable court.
But I am
But the question of the second part is concerned, my lord, I think that is more, my lord, that is more important in this case.
Yes.
Now, that is, my lord, your lordship can refer the issue to the state.
Why refer?
yeah, they have already
But
decided.
those-
I shall not refer. I was trying to find out the judgment and I shall rely that judgment.
Lordship got it, Malad.
That Shaharapad.
That
Sahan apartment.
Saharmanu I have got,
Yes.
and that judgment, it is Sunu, the Honorable Supreme Court 2004, volume 8, SCC page 683. I am compelled to refer this judgment, where the Honorable Court lamented that it has become a tendency with the government officer to somehow or other circumvent the orders of the court, or try to recourse to one justification with another,
Yes.
and to stick to their position.
Yes, appropriate in this case, Malad. Malad, kindly, Malad.
It is the experience of wiser head, and it is the experience of ours also. We have also experienced. You send back them.
So, my lord, in
You send back his issue. Actually, why court send back? Court does not want to intervene or encroach upon their area. They will run their own administration. Court will not run their administration.
my lord, may I
Court
say-
will not undertake that liability.
My lord, these two appeals, my lord, which was referred to, my lord, by the DPO, when those two appeals were taken up, and my lord, when the issue was, my lord, referred to the state project director, my lord, he had done the administrative justice, my lord. He immediately, my lord, extended the benefit.
Yes.
Not that
Still, the appeal was kept pending.
before that, my lord, it was, my lord, said before the court that yes, he is entitled.
But it is our experience, since we are saying that it's fall within your domain to consider, and some question of facts is involved. So I am referring this matter to you, remitted this matter to you. You just here also your attendance sheet is to be checked whether court will undertake this clerical job. I refer to,
Thrice
you
their
send to the expert person.
thrice their
That what they
competence
will see, they will do, they will again stuck to their decision taken earlier.
Yes.
There should not be any ego.
Okay, ego. And force the person, you go again. For how many times you can go, you go. I shall see. In this way.
Administration,
But
my lord,
I have-
to discharge its duty, my lord, court has every power to issue
I have to-
mandamus.
Actually, there are two types of philosophy, whether we are dispensing justice or whether we are removing the injustice.
Why not just removing the injustice?
Injustice is there. We are not being able to give justice. We are removing injustice. Here there is an injustice. Okay, I am to read this. Here there is injustice. I am to read this. Injustice is inherent in our society. In a society.
In our society,
Society. We have to remove.
That's
We
why
have to read this.
judicial system is there.
Yes. So you bring the
Malad,
supplementary.
I-
I am keeping it under the heading for orders.
Very
Or the date order will be.
Very good, Malad. Malad, I have to file supplementary affidavit or I can bring the judgments on the matter. I say judgments.
Supplementary affidavit.
Mr. Mukherjee has given one, but it is a modification most
Yes, yes,
probably of earlier
I
order.
shall bring it.
So
So I shall bring it by way of supplementary affidavit, or I can hand it over to your lordship, my lord, as your lordship, my lord. If your lordship say so that I have to file supplementary affidavit, I
so
can.
bring it,
Very well.
bring it. When you will bring it, tell.
Next week, any day, after 21st, 21st will be some difficulty, my lord. 22nd, 23rd, any day.
এই কবে আছে 23rd আচ্ছা হার দ্য লার্নেড অ্যাডভোকেট অ্যাপিলিং ফর দ্য রেসপেক্টিভ পার্টিস আচ্ছা লিস্ট দ্য ম্যাটার আন্ডার দ্য হেডিং ফর অর্ডারস অন 23rd 23rd এটা উপরের দিকে দিয়ে দেন ফেয়ারলি অ্যাট দ্য টপ অফ দ্য লিস্ট 23rd এইটা আপনি আজকে ইয়ে করে পাঠিয়ে দেবেন ইয়েস নেক্সট
This has come up for correction, my lord. In my lord's judgment, in paragraph 46 of my lord's judgment, my lord had directed
Yes, Mr. Jahan is there.
is for the respondent. My lord had directed the chairman of the UGC to appoint an expert of unquestionable integrity and impartiality who shall remain uninfluenced by any extraneous considerations of the disturbance.
Page 31, paragraph
46.
46.
Yes, my lord, this
No, UGC is the appropriate authority. Because the AICT regulation says there are two types of post. One is technical faculty, another is non-technical faculty. Now, Rule 5(1) says if it's faculty of science, then the UGC is the authority. The same rule says it so. So, direction is appropriately correct.
my lord would kindly keep it tomorrow because I'm being led by Mr. Kolwal Basu. He was there all this while. He had to leave because the matter had been
No,
taken.
what Mr. Jahan has.
I understand.
Have you understand?
I have understood. my lord.
He is a assistant teacher in physics.
Physics, not
He
technical
cannot be
subject.
stated to be a technical post. It cannot be
understand.
stated to a technical post. Engineer, such and such, it would be technical post. In that circumstance, AICT, yeah. And hence the court thought it. However, your technical institute, considering this fact, I allowed your mentioning.
Mr. Basu was of another opinion, my lord. May I kindly come back tomorrow? My lord kindly keeps the matter tomorrow.
He is the institute before us.
Kindly take up the regulation. I have already supplied with my opposition. Page 39, I have annexed that. দেখো এই যেটা means এটা 5 বলছে qualification for
Okay, I am keeping it under the heading tomorrow.
tomorrow I would not be there.
Oh, Monday. Monday, where is Mr. He is engaged in another court. Oh,
My lord kindly Tuesday, my lord kindly Tuesday. Monday perhaps, my lord, there is some difficulty, I'm told.
oh.
21st July.
Monday, what we will do?
21st July.
I would be here.
Now,
I
what we will do?
I am told Mr. Basu would have some difficulty, perhaps. I don't know what difficulty. But kindly keeps it to
You come,
I will. Kindly keeps it Tuesday.
you come.
I will be there. I definitely will do it. But my lord, since
Monday, we have to do some job.
absolutely every one of us would do.
What we will do?
All of us would do. But my lord, the traffic and everything, my lord, we are not sure.
No, don't. Come. What? এটা কত মেটা তাহলে মঙ্গলবার টু বি মেনশন রেখে দিন 1 মিনিটের ব্যাপার টু মেনশন
Great.
হ্যাঁ ওই আপনার
Grateful.
22nd July to be mentioned. Any order is required to be passed. Then,
Disposed of matter.
yes, no order. Yes,
My lord, I beg to appear on behalf of the writ petitioner, petitioner, my lord.
The respondents.
My lord, this is a substitution application, my lord. The writ petitioner have died on 12th of February 2025, my lord. This year, my lord. The appellant,
Substitutionটাকে করতে
আচ্ছা নম্বর আগে সাবস্টিটিউশনটা করে নি
Substitution
হ্যাঁ
আগে কোনটা করছো?
সাবস্টিটিউশনটা আমার তো একটাই অ্যাপ্লিকেশন আছে একটা তো রিমান্ড অফ ব্রেক হচ্ছে ডিভিশন বেঞ্চ থেকে দ্য ম্যাটার হ্যাজ কাম বলছি
Yes,
My lord, I am for the applicant, my lord. The applicant here, before your lordships are the wife and daughter and sons of the deceased writ petitioner, my lord. The deceased writ petitioner had died in a road accident, my lord, on 12th February 2025. The death certificate has been annexed at page number 32. Can 2, my lord.
petition, petition.
Can 2.
What is the writ petition?
4611.
If you reconstruct, কি রেকর্ডটা রিট পিটিশনটা দেখুন তো রিট পিটিশনই নেই হ্যাঁ দেখি হ্যাঁ till then you state the fact. What is the fact?
My lord, the writ petitioner was an employee of Calcutta Port Trust, my lord.
Port trust.
Calcutta
Yes.
Port Trust, my lord.
Yes.
He has been engaged in the port trust in the year 1983, my lord. Since then, my lord, he is serving as a medical attendant in the. Since then, my lord, he has been serving the port trust as a medical attendant, my lord. In year 2017, my lord, after 35 years of the service of the writ petitioner, my lord, suddenly the respondent have issued a notice that you have to retire from the service from 30th February up to
service to. Oh. The record was reconstructed.
No, my lord. Kindly come to the page number 44 of writ petitioner, my lord. After 35 years of service of the writ petitioner, my lord.
So the entire facts, your lordship, kindly see the appeal court's order, my lord, at page 47 of his
Application, my lord.
That will suffice, my lord, everything, my lordship.
Let me place the case now. I am coming to the division bench order.
Yes. So suddenly after rendering
5 years of service,
they said that you have to retire.
You have to retire with effect from 30th of April 2018, my lord.
30th April
2018, my lord. As per service record, my lord, my date of birth has been recorded in the year 1963. So, my lord, I was to retire in the year 2023, my lord.
Yes.
In spite of the fact, my lord, that I have to the rate of retirement fall in 2023, my lord, they have superannuated me in the year 2018, my lord. Prior to after receiving the notice of superannuation, my lord, I have approached this honorable court in the year 2017, my lord. Prior to my retirement, my lord, the writ petition was disposed by the Honorable Justice Somabuddha Chakravarti. The order is at page 50, my lord. 50 of the writ petition.
Yes.
The Honorable Single Bench held that I have not made any representation before the respondent, so I was directed to make a representation, and the respondent were directed to afford an opportunity of hearing and pass a regional order, my lord. Subsequent to this order, my lord, a hearing was conducted and the authority passed an order, my lord. That is page 58 and 59, my lord. 58 and 59 of the writ petition, my lord.
Yes.
My lord. That is most important portion is page number 59, my lord.
Yes.
The last second paragraph, my lord, where the respondent had admitted that there has been a mistake committed by the respondent. I read out, my lord, for your lordship. And where this is a case of bona fide mistakes. Case of bona fide mistakes, my lord. The respondent have recognized their mistakes after 35 years of service of the writ petitioner, my lord. This is not the case where the writ petitioner have challenged his date of birth after the 35 years of service, my lord, to extend the tenure of his service, my lord. This is the case, my lord, where the respondent, after 35 of the service, my lord, have come forward and challenges the date of birth of the petitioner, which has been recorded in the service book, my lord. Now, my lord, I am cutting short my arguments. In this matter, my lord, the affidavit have been
Challenging this order, you have come.
No, there is a long history in the case, my lord. The affidavit was exchanged between the party before the Honorable Justice Sampa Sarkar, my lord. But due to change of determination, my lord, the matter come before the Honorable Justice Rajasekhar Manta, my lord. And the Honorable Justice Rajasekhar Manta was of the opinion that a accurate age can be determined by the test of ossification test, my lord. And by the order dated 19th November 2019, the Honorable Single Bench, presided by the Honorable Justice Mantha, directed for the ossification test, my lord. And my lord, to show his benefit, my lord, the ossification test was conducted. The petitioner underwent ossification test on 20th of January 2020, my lord. Kindly note it.
May I deal?
20th of January 2020, my lord. The Honorable Justice Mantha directed the respondent to conduct the, kindly come to the order dated 19th November 2029. The Honorable Justice Mantha directed the respondent to conduct the ossification test and supply a report thereof, my lord. The ossification test was conducted on 20th January 2020, my lord. Till date, my lord, report of the ossification test was not supplied to the writ petitioner, has not been supplied to the court itself, my lord. Even the division bench of this honorable court also directed and asked for the ossification test, my lord, report of the ossification test.
Ossification test was done by whom? By which authority?
By the respondent, SSKM.
It would be by a doctor in a hospital.
My lord, at the stance of in the compliance of the order passed by this honorable court.
Bearing on behalf submit the direction for test of in respect of appellant was not justified. We also submitted the appellant as appears. So in such circumstances, Kolkata Port Trust is directed to inform this court as regards to the ossification test
My lord,
of the said appellant after obtaining the ossification test report from the SSKM hospital.
now
You produce.
Sir, I'm saying, let him finish. I mean, my lord, what happened in this matter?
now, my lord, can we,
Moral submission will not, Mr. Jana will not.
As
You
regards-
just produce the ossification.
regards to
kindly
the-
come to the.
As regards to the ossification test, I will make 2 or 3 submissions, nothing more. Because everything has been directed by the division bench. Pursuant to the direction, ossification test has to be held by the SSKM hospital. Now, what happened, my lord? Notice, we have issued a notice on 3rd January 2020 to SSKM hospital for ossification test. My lord, thereafter, my lord, he was directed by memo dated such and such, wherein he was directed to appear before the medical examination on 19th February 2020 at 12 noon. But the petitioner did not appear for said examination, and another date fixed on 3rd March was fixed by HOD SSKM test such and such. The judges are duly informed by the CMO, Chief Medical Officer of the Port Trust, by his office letter dated 25th February 2021 to appear before the medical. I do not know what happened thereafter.
I
He did
explain.
not appear.
I explain,
Procedure
my
was
lord.
there.
Kindly
I
come.
informed the SSKM. I inform him.
Let me,
If nobody will go there,
my lord,
if no medical test, ossification test will be done. what
kindly
is
come to the
responsible?
order dated
My
25th
duty
of.
is to cooperate and to take steps. Immediately I have taken steps. I have informed him. I
Hello.
informed SSKM hospital. Thereafter, he did not appear. I informed the CMO and also him.
My lord, kindly come to the order dated 25th of January 2020, passed by the learned single bench, my lord. Kindly,
Court will go to the order letter. You just satisfy
kindly come to
whether you appeared before
the
the,
lord. My lord, I appear that there is an order passed by this honorable court.
whether ossification test was done
Kindly come to the order 25th
Whether
of Jan-
ossification test was done.
Yes, my lord.
Whether he has appeared on 19th February and 3rd
I
March
read out
twice.
for
Whether he has appeared
by
or
an
not.
order dated November 1920, passed in the writ petition, Calcutta, directed to Calcutta Port Trust to arrange for an ossification test. It is submitted the SSKM hospital has conducted the ossification test, but has not circulated the report between the party. In those circumstances, the superintendent of SSKM hospital shall within a period of 7 days from the receipt of the server copy of this order make available the result of ossification test and report of Calcutta Post Trust as well as the petitioner positively and mandatorily. Kindly come to the page number order dated 25th of January 2021, my lord.
Page কত কার সঙ্গে করেছে?
এটা অনারেবল জাস্টিস
না না কোন কার সঙ্গে ওটা annex করা হয়েছে?
এটা ক্যান 1 এর সাথে
কেন ওটা কি ভাই?
না না ম্যাটের সাথে হবে
On 9th January 2023,
20
Division Bench of this court passed an order recorded Mr. Bhattacharya
Kindly-
submission. That means the appellant submission, your submission.
my lord, kindly come to the
That said, appellant, namely the writ petitioner had
Stop.
appeared for ossification test before the concerned.
I am
Committee.
not clear to you, your lordship, my lord. But the ossification test was conducted on January 2020. Thereafter, report was not supplied. I came before this honorable court by filing an application can 1 of 2020. That can was disposed by the Honorable Justice Mantha, directing the claims, the order that I read out for your lordship on the 25th of January 2021, 25th of January 2021, whereby the respondent were directed to collect the report from the SSKM and supply to the petitioner, my lord. And the writ petition was disposed of without going into the merit. I challenge the order of the disposal of the writ petition before the division bench. The division bench disposed the appeal by the order dated 27th June 2023 that has been annexed with the can application number 2, page number 47 onward, my lord. Kindly come to the page number 47.
Yes, what division bench observed?
The relevant portion is page 59. Accordingly, the order of single bench stand modified to the extent that result of ossification test shall be placed before the honorable single bench in WPA 4611/2018, which now stand remanded to the honorable single bench for further hearing, which will take appropriate decision on the basis of further fact. This is the direction passed by the honorable division bench. Therefore, my lord,
Who will produce? So the respondent will produce.
respondent will produce. I am the petitioner. I undergo for their satisfaction. I undergone into this test. The test was conducted in January 2020. We are in 2025. Till date, there is no report. The division bench directed that I place before the no report was placed before the division bench. Finally, division bench remand the matter before the single bench as the ossification test has been conducted to place the report and decide the issue. 5 years have been passed, my lord. There is no report from the end of the respondent, my lord. In the meantime, my lord, after the expiry of the tenure in a road accident, my lord, unfortunately, the petitioner died in this year in a road accident, my lord, on February 25, my lord.
This year, petitioner died.
My lord, February in a
So
road.
bring the legal heirs of the petitioner on record.
The can 2 is for the substitution, my lord. The applicant.
So let the can 2 taken up first. Otherwise, the writ petition filed by the deceased petitioner cannot be here. So I allow the
My lord, now what would happen, my lord? Subject to, I am not standing in the way for allowing the substitution. Only the thing, my lord, ossification test as direct last order is the division bench. This problem can be solved only after having a ossification test. Thorough litigation since inception, last order is the division bench. He went to the Supreme Court.
Yes, my lord. I
It
went.
was dismissed.
No, my appeal was dismissed just because the writ petition is pending, my lord.
আমাকে বলতে 2 মিনিট আমি বেশি সময় বলবো না। He has annexed. I have not annexed.
At page 60.
Yes.
okay. Let me first allow his substitution.
No, what will happen? Allow, no problem, my lord. Whose ossification test now will be taken?
Huh?
Who will be?
I have underwent to the ossification
You have
test.
taken the
Test, my lord.
return benefit.
Retirement benefit, I do not know. That is,
My lord,
oh, no, retirement benefit. I am
No.
ready to give him what is my date of birth recorded in my. He has said, no, I will. I will not.
rely upon a Supreme Court judgment, my lord.
Yeah,
The
substitution.
no, for the merit, my lord.
Merit টা আগে substitution টা দেখো তারপরে merit এ।
Whereas the Honorable Supreme Court has held that the employer can also not challenge the date of birth of an employee at the fag end of the service, my lord.
হ্যাঁ
At the fag end of the service, the employer cannot challenge the date of birth of the
হ্যাঁ
employee, my
ইট
lord.
ইজ ওয়েল সেটেল হ্যাঁ
The order was passed by the Honorable Justice D. Y. Chandrachud and Honorable Justice Anuruddha Bose.
আচ্ছা আপনি লিখুন তো can 2 of 2025 আচ্ছা লিখুন this application this is an application for substitution. Stop. Your good name please.
Surendra Kumar Sharma, my lord.
আচ্ছা Mr. Sharma, learned advocate, repenting
Item 74, my lord. I'm for dedicated freight corridor, my lord. I'm led by Satendra Agarwal, my lord. As early morning, he mentioned, my lord, he's not feeling unwell, my lord. He late for today, my lord.
কি হয়েছে
হঠাৎ সকালবেলা এসেছিল।
বোঝো কি হচ্ছে বুঝতেই পারছি না।
One day accommodation, my
যেদিনই
lord.
মামলা ধরছে হি ইজ সাম হ্যাভিং সাম ডিফিকাল্টি। কি হয়েছে
Monday, Monday
জ্বর
can.
এসে গেল ভাল্লুক জ্বর নাকি এটা
No, no, yeah.
মামলা দেখেই জ্বর এসে যাচ্ছে বলছে।
And so I heard, they are, so heard the learned advocate appearing for the respective
Really?
parties. Give your name. Give your name, list the matter for further. Yes. Item number 20, updated matter. এই মানুষ আসবে না, ফলো করতে পারবে না, এটা আপনার জন্য। আমরা বলতে বলতে আসছিলাম, মানুষ এটা ধরতেই পাবে না। আজকে ইয়ে করাটা উচিত হবে না নাকি? এখন আপগ্রেডেড করে পম্পাদের খবর। What can be done? পম্পাদের খবর 24 অ্যাপে বিষয় প্রসাদ বসু, অরিন্দম মিত্র। তো এটা হেয়ারিং এ দিয়ে দেবেন, নট টুডে, হেয়ারিং। নেক্সট ডাকুন। এই রে, তাহলে কিন্তু সবাই ভুল করছে বোধহয়। ডেকে যান তাহলে, আপনার কিছু করতে হবে না, তাহলে ডেকে যান, পরে এই আপগ্রেডেড ম্যাটারটা পরে যদি
22, 23.
My lord, 23, I am for the petitioner, my lord, led by Ms. Devjani Sengupta. My lord, scenario is coming, my lord. I am praying for short Passover.
নট টুডে, নিন।
24, 25, 26, 27, 28.
Yes. Who is your other side?
Shamaiti and Sujoy Bondopadhyay.
That municipality matter.
Taking money, regularization of the building.
Eh?
Regularization of the building by imposing fine.
Oh, your pair.
That they have done so. That which
Oh.
is the chapter.
So your contention is that municipality cannot do so.
So my challenge is my primary, that my threefold submission. One is the plan is sanctioned illegally. Second, building was construction without sanction plan. Third, cannot regularize the building. Cannot regularize the plan by taking penalty. These are my three contentions.
So what can be done? Not today, Kurun, what can be done? Not today, what can be done? Yes, দেখে যান।
29,
It will remain in the same place or it will go down again.
Reshuffle, it would be reshuffle.
For example, it is second time they are not appearing, third time they are not appearing. This 3-4 occasion they have taken time. I never paid for time. There are 3-4 occasion this is being going on.
আচ্ছা একটা অর্ডার লিখে নিন তো। আচ্ছা despite repeat despite আচ্ছা despite লিখতে হবে না যে the respondents are unrepresented though Mr. Bhattacharya, learned advocate representing the petitioner, is present. So, you are?
Sorry, my lord.
Is for the municipality.
I am for the Mirzapur municipality, my lord.
Municipality.
In item number 28, my lord.
Yes. Place your case. Yes.
Before your lordship is the adjacent owner where the construction of the building is being carried out. And on the page 49 first.
Okay, I'm coming. There was a contempt application also.
Contempt application was there. You have constructed the building.
In violation of the court of this court orders. Yes. What is the memo impugned order dated 11th?
88.
Page 88. Yes. If the constructed building has a story to is ordered for, it will cause havoc loss. So they have accepted your plea, but they concluded that if the direction for demolition is given, there will be a havoc loss, and hence they
That
took.
is their contention. My specific allegation is that plan was sanctioned illegally, number one. Number two, building was constructed without any sanction plan. Number three, by the impugner, they have regularized the same by taking money, by taking penalty. That cannot be done. These are my three contention, all through.
Yes. Place your case.
Kindly first come to the page 49.
My lord, and my lord, I am ready with the matter, but it has sufficiently got a mutual appealing. They have already asked me that it will be upgraded, but my clerk failed to notice that. I have not.
You have not bought the bill.
Kindly pardon me for my fault.
When on that date it appeared through VC, most probably. I can recall now. VC, then you took time.
On that day, my lord, I was not in a position to.
Your learned friend is coming again and again in this matter.
I came to the lawsuit to move this matter. I was ready with the matter, but today, unfortunately, that on that matter, never it was called on.
Actually, I am reshuffling. Today is updated. Tomorrow, returnable matter will be placed. Suppose then after assigned matter will be said. Pathat.
Any day. Any day. Any day subject to your convenience to your lordship. Any day.
এটা মিস আপনার বিয়ে করে ফেলেছে সে। So it would be August. What can be done?
August. But you see, I have never prayed for in time, never.
Specially fixed cannot be. So let it remain. Let it remain under the heading upgraded matter. On the date upgraded matter will be taken up, it would be taken up. Let it retain its position.
For this day only, I shall not be able to. Any day your lordship.
এই আপনার একটা ফাঁকা দেখে দেখুন তো, যেদিন একটা দিয়ে দেবেন তো তাহলে একটা স্পেশালি বার করে, হ্যাঁ আগস্ট না এই মাসে তো হবে না, সব বুক করে নিয়েছে। Your learned friend has already booked this month. Even what can be done? To pay.
Need it.
এই 11 এম আর ওই 12 তুলে ব্লক হয়ে যাচ্ছে, ছোট যাচ্ছে। তার আগে নেই। If you take two time, it would be 8 August. Before that, no date is available. 2 p.m.
In that event, 8 hours, 2 p.m.
8 August 2 p.m. হবে তো? 8 August 2 p.m. It would. আচ্ছা, had the learned advocate appearing for the respective parties, list the matter, place the matter in the list on 8 August for further.
Consideration. My lord, here what has happened is, my lord, the higher scale of pay, my lord, of this petitioner, my lord, has been turned down by the authorities.
Why? What is the cause?
Now, my lord, the cause is, my lord, may I, my lord, place the documents. Now, my lord, kindly comes to Annexure P3 at page 29.
Higher scale of pay due to improvement is qualifications. Okay. So when you join?
My lord, I was selected by the Regional School Service Commission.
Yes.
But initially in the year, my lord, 2001.
2001 selected.
Yes.
Joined?
My lord, joined. I joined immediately thereafter. Initially, Bosh. My lord, but I was initially, my lord, I joined in Hulud Khanali, my lord. But I was an assistant teacher in language group. I initially joined in Hulud Khanali Schedule Caste High School.
When?
But I joined on 3rd of October 1997.
3rd of October 1997.
But thereafter, in
1997, based on the recommendation made by the School Service Commission.
Lordship.
Yes.
But thereafter, I sought for.
You joined in honors category or pass category?
Honors category.
Honors category. Yes.
Because, my lord, my educational qualification at that time was BA honors in English language.
BA honors in English. Yes.
Lordship. My lord, thereafter, my lord, I sought for transfer. My lord, I was transferred, my lord, by the, my lord,
board.
My lord, to Mushiara High School. Mushiara High School in Bankura.
Acha, Mushiara High School in Bankura.
The lordship would get my approval of appointment at page 31.
When it was approved?
It was approved on 28th of November 2002.
28th of November 2000.
By the District Inspector of Schools, AC Bankura.
Okay.
Now,
when you improved your qualification?
I improved my qualification, my lord, on taking permission from the school, my lord, on 3rd of September 2009.
Managing Committee, 3rd of September
2009.
2009, yes.
Now, my lord, I my lord, obtain my higher qualification, which is MA in English honors.
MA in English, so relevant in your teaching subject.
Yes.
Yes.
Now, my lord, on 4th of July, my lord, the school authorities, my lord, after
Forwarded your pair for grant of higher scale of pay. They rejected on the ground that you did not take prior permission from the DI.
lordship.
I have stated.
Now, my lord, what had happened there was, my lord, I made a representation.
My lord, before my learned friend start being an officer of this court, I shall point out something before your lordship. My lord, the case of the petitioner initial stage is that he made a representation for granting higher scale of pay that has not been considered by the DI. For consideration, he approached this honorable court. My lord, the honorable court directed us to file a report. My lord, we file a report annexing the reason. It is not a reasoned order, but annexing the order. Well, subsequently, Utpal Karan's judgment, larger bench came into. Now the situation is completely changed. Well, now the situation is completely changed.
Yes.
Well, at that juncture, my lord, being an officer of this court, I pray before your lordship, kindly set aside this order and
Yes.
demand it back to the commissioner, not DI, commissioner of.
Why? I shall ask the DI to grant higher
Yes.
scale of pay. No, not consideration.
But I shall-
In the morning, I have stated that there is a tendency, growing tendency, the observation of the Supreme Court. As and when the matter is being remitted, they are remain stuck to their position.
And my lord, the circular,
I have passed order. I have passed order in this case, several order I have passed. You will find it out. Whether you did. No. Sajan Ali has did many matter, many advocates have done. Okay. So I am directing them to grant as per the decision of
I am
the
entitled, but there is no
Utpal
bar.
Karan. I am already passed that order.
And my lord, they have only rejected me.
And this order thereafter, there was a circular whereby state came with disclosed its stance that no permission is required to be taken from the DI.
My lord,
Permission of the managing committee is, have you brought that
Yes, yes,
circular?
yes. No, my lord, that circular is not with me.
That circular is
I
there.
accept the proposition.
Yes.
Not quarreling with that. My lord, only.
No. The word is used competent authority. Then dispute arose, who would be the
My
competent
lord,
authority?
my understanding is the competent authority is managing.
Managing committee.
But my lord,
Yeah.
for granting higher scale, my lord, there is differences between the two aspects. Number one is that who is the competent authority to grant prior permission for appearing in the
Yes.
examination.
Yes.
Second is to grant the financial benefit. My lord, well aware that, my lord, I obtain a prior permission from the managing committee for seat in the examination. He is the competent authority. But my lord, when I am claiming the financial benefit, my lord, prior permission is state is required. That is my understanding.
No, that decision also, that circular.
That's why, my lord, that's why I beseech your lordship. That's why, my lord, I beseech your lordship, being an officer of the, at the instance I pointed out, my lord, this order after Tarok Karan's, my lord, cannot stand. My lord,
Utpal Kantikaran.
Utpal Kantikaran cannot stand. My lord, that's why, my lord, I am beseech your lordship not to relegate the matter to DI, but the highest authority, Commissioner of School Education. My lord, kindly do not dispose it of this writ application. Let him place his order before your lordship.
It is available.
My lord, the order
I
of
have
the.
to find it out.
No, my lord, I am not saying that. My lord, I am only saying that do not dispose it of this writ application. My lord, send it for taking a decision before the Commissioner of School Education and direct the Commissioner of School Education to place his order before your lordship. Whether they can take the same steps or not, that will be clear from that.
Okay, I am disposing of this. I don't know whether I shall be able to find out that circular.
My lord, My lord, I am only praying before your lordship.
I shall
Dispose
find
it
it
off.
out.
My lord, do not dispose it of. My lord, delegate the matter to the Commissioner of School Education with a direction to place his order before your lordship after 3 weeks. I think, my lord, Commissioner of School Education shall grant this.
Oh, okay. In questioning the justifiability of the order I'll put the date. And I have also referred to one circular competent authority. I shall put the date. I shall put the citation of Utpal Kanti Karan and such and such. Okay.
Given Utpal Kanti Karan's
Yes, yes, yes.
Lordship, one thing. Item number 118, it is returnable hearing matter. The other side is present. Kindly fix a date for conveniently. It is not reaching.
In this
118.
way it cannot be.
Kindly fix any day, any convenient.
No. You mentioned this matter later on, it would be placed. What? It is not mentioning time. It is not mentioning time.
Item number 24 minute collapse minute. I could not reach minute.
What collapse?
The list got collapsed minute.
List collapse.
If it could be minute, return solution.
ওকে রিটেন এগুলো রিটেন করে দেবেন, কিন্তু কবে আবার আপগ্রেডের ম্যাটার নেবো এগুলো বাদ দিয়ে নেবো নাকি? এরা আসেনি তো, এগুলো বাদ দিয়ে নেওয়া উচিত। হ্যাঁ, ঠিক আছে। Now you should have, you also should have, I am not blaming you, brought to the notice of the court that today average side matters and with. It's also mine. I know, and hence I am saying so. Okay, yes,
Madam,
sir.
may I permit to mention one matter? Madam, in the morning also I mentioned my lord said on the original side time. My lord, this is the matter. My petitioner is a senior citizen. The writ petition was filed on 2021. Due to the lack of determination, the my lord, this matter was never taken up for hearing. My lord, time oblige, my lord.
May I be allowed to mention a matter for inclusion in urgent hearing? Your Lordship, I am DVC. Certain employees, I am Damodar Valley Corporation. Certain employees were hired on a consolidated pay. Now their account has been regularized. Now what has happened? There are certain.
You DVC, you have filed a petition.
So I'm the respondent. My urgency, Your Lordship, is that the petitioners are about to retire. Once they retire, I cannot.
A very good employer. Model employer in proper, in appropriate sense you are. Your employee, you are thinking your employee going to retire, you will not get retirement benefit. Give it. Who is your other side?
I will mention before the matter is moved.
Yes, yes, it will be taken up. Yes, call the list, please.
Original side,
Madam, I
item
tendered
number
apology.
1.
It was not in the, I missed it. Yes, yes, my officer also did not bring it.
I shall give reply to my petition.
Yes.
The court has already concluded his submission.
The only thing, there was a development. My learned senior friend had used an affidavit after our submission, supplementary, wherein we had filed our objections. My lord would kindly see the last order. My lord, kindly see. My lord, that issue, whether this affidavit could be taken into consideration or not, my lord wanted to hear this.
This has been filed with leave of the honorable court.
My lord, kindly see, my lord. Subject to correction, my lord.
Only a document has been enclosed. I shall disclose my supplementary evidence.
Okay, it would be.
My lord, let my learned senior friend complete, then I will reply. Mr. Kaur is coming, Mr. Kaur.
Oh, okay.
If my learned senior uses, relies on that affidavit, my lord, we have to.
I have annexed their document.
After the pleadings are complete, my lord, we have learned from lordships that after trial, order 6, rule 17 is not allowed. It is after hearing, affidavits are complete, after our submission, some documents are coming.
Because you have taken a plea which is not correct.
Now, how it will be prejudice?
We'll submit.
I have annexed their document, only one document I shall rely upon from the supplement.
My lord, question subject to correction or what we have learned, my lord, additional evidence also. There has to be some pleading that.
Question of the court is how will it become prejudiced?
Well, I'll answer to that. Let me, my learned said, if he relies at all. If he relies on at all.
Okay, yes.
But just before you reply, my lord, two sub-rules of the service rule I have placed before your lordship. Just I shall place the same. Kindly turn to page 25 of my writ petition. The rule governing the service condition, terms and promotion and that's the seniority of the High Court officials.
Yes.
Kindly read my lord order. Rule. This rule shall be called the Calcutta High Court Service Appellate Side Categorization of Post Channels of Promotion and Financial Humanities also. Then my lord, you shall kindly come to page 27. These are very relevant. Page 27, bottom portion 6.2, caption said determination of seniority of promotees.
Yes.
Seniority of persons appointed on promotion to any post shall be determined from the date of joining the post. Well, this is our case also. So when a person will join in his promotional post, his seniority to the next post shall be considered the same date. That is the feeder post. Now, your lordship, another provision I have shown to your lordship. Next page, kindly turn the page. Page number clause number 8. Bottom portion, page 28.
Yes.
There shall be prepared a branch wise and categorize. Kindly take note of category wise. Gradation list of all staff on the basis of the principles enumerated herein above. Herein above means I have shown to your lordship 6.2.
and it shall be kept continuous revised. The gradation list shall be published every 5 years. Now kindly take up my petition, paragraph 12, page 10. Opposition. I'm reading paragraph 12, just a small paragraph.
Yes, paragraph 12.
At page, my lord, 10 of my petition.
No, page 9, yes.
Page 10, my lord.
Okay, paragraph 12 you read.
My lord. Your petition states that ever since your petitioner were promoted through selection of the post of superintendent grade 2 of the superintendent 2 category, no category-wise gradation list of the general branch of the establishment has yet been published following the mandate contained in Rule 8 of the 1986. Actually, for last 2 years, there is no gradation list. Question of revision does not even arise at all. No gradation list has ever been published by the High Court, at least for last 20 years. But this paragraph has been dealt with by the High Court authority. If you kindly take up their opposition, paragraph 12, they have not denied it. Opposition, paragraph 10 at page 14. They have dealt with paragraph 12.
Opposition didn't.
Paragraph 10 at page 14 of the opposition, they have
Yes.
dealt with my paragraph 12. Kindly take up my paragraph 10.
Yes.
At page 14. I am reading, my lord. With reference to the statement made in paragraph 9 to 12, my lord, I have shown to your lordship paragraph 12. Of the said interpretation 7, except what are matters of record, each and every allegation contained therein is denied. It is stated that the petition number 1, 2 were asked to officiate as superintending portfolio or petitioner works to officiate the superintendent so and so house at Bijan Bhavan in the same day, same pay band with a higher minimum pay only on the basis of the selection criteria, which is other than the selection process entertained in the rules of so and so. The petitioner thus cannot claim accelerated promotion from 2018 and still a march over incumbents who were senior to him in the upper division assistant category. At this period of time, the senior was promoted to the process of so and so. Their universities denied the incumbent who were senior to the so and so category voluntarily, chose not to offer their candidature, but for being considered to such promotional post of superintendent grade 2 category despite being the otherwise eligible. As alleged or at all, the notification did not permit all the candidates to apply for the post. It is denied that the petitioners were appointed following Rule 5(1) of the 1980 rules. As alleged or at all, it is disputed that there is no category-wise gradation list of the central branch. Can I take note of on the appellate side, the seniority in service is maintained in the establishment register where details of the appointment, promotion of the different categories of post from the post of lower division assistant to joint register entertain the concerned assistant for permanent to act in the post. There is no specific denial, no document has been annexed that the gradation list being published or revised. There is no whisper. They have not categorically denied also. Now, your lordship, kindly take up my petition, the promotion order. My learned friend has taken 3 points so far opposition is concerned. The first point taken, my lord, delay to file the writ petition. My specific case is that since you have not published any gradation list, I am not aware who has superseded me. In their opposition, they have not denied the same also. Unless there is a gradation list, I cannot ascertain who has been superseded me. From 2018, I have been promoted 2018 to 2023. There is no gradation list. I made representations one after another that has not been replied with also. So it is not possible to file the writ petition unless I came to learn that these people has been superseded me.
Yes.
Proceed, kindly take up there to your page 10 I have seen. So far the delay is concerned, my specific case is that this is not fatal also, and I am not praying cancellation of promotion of any people. That is not my case also. Had they can show that they have published the gradation list, the question of arising the point of delay only does come. This admitted position, no gradation list has been published by the High Court authority at least till 2018. So the rule says, well, even every alternative 5 years there should be a revision. That has also not been done. The moment I came to learn these people has been superseded me, I came before this honorable court. The second point which has been urged by my learned senior friend Mr. Kaur, officiating post. Their case is that this is not a regular promotion. This is a exceptional case. I have been officiated to the promotional post, so that cannot be considered as my promotion. But kindly take up my promotional order at page 37 and 38.
Yes.
There are 3 petitioners. So far, the first document is concerned, that is page 37. Order of promotion of 2 petitioners, that is petition number 1 and 2. Well, I am reading. In exercise of the power delegated to me by the Honorable the Chief Justice under the Lordship's order dated 11 February 1998 and pursuant to the order of the Honorable Chief Justice dated 30 July 2018, I do hereby appoint the following upper division assistant presently born in the interim revised pay band scale of rupees 7,100 to 37,600 PP3 with so and so, or pay of rupees 7,910 with the grade pay of rupees 3,600 with other allowances under the Calcutta High Court, appellate side, original side, services, interim revision of allowance rules to officiate. But this has been hard. I have been promoted to officiate the post. The case sought to be made out by the respondents in their opposition, and that was also argued by my learned senior friend. In the 2 posts, superintendent on promotion having been selected for the said promotional post in the interim revised pay scale of rupees so and so with minimum pay of rupees so and so, grade pay rupees 4,220. So my pay scale has also been enhanced. After promotion, my pay scale has been enhanced also. So it is promotional post. I shall show to your lordship. Together with so and so, kindly see that then the table. Sri Shomik Bhattacharya, he is the petition number 1. Sri Kaushik Chakraborty Thakur is the petition number 2. Kindly see the right hand side table. Sri Partha Gupta, superintendent protocol, promoted to the post of so and so, vice. So in his place, I have been promoted to the post of so and so. Like that, my lord, the 7 tables, the Shondipan Chatterjee, vice, superintendent protocol, promoted to the post of section officer. So after their promotion, in this post, I have been promoted. Now kindly come the next page, another promotion. There are 3 petitioners. Same language has been issued, used. Officiating, pay scale is higher as promoted to the higher post. All this promotion has been given effect from 30th July 2018. My specific case I have made out in my declaration from 30th July 2018. No gradation list has been published and question of revision of such gradation list even does not arise. My case is that for last 20 years it has not been done. But I came to learn, so far the superstition is concerned, so far my client is concerned, only in the year 2023. Unless there is a gradation list, I cannot ascertain. The juniors have been superseded to me.
Yes.
So far officiating, so far officiating parts it concerned, regulatory, kindly take up my supplementary evidence.
But if your lordship permits, Lord, then Lord, let me first, Lord, take the point that supplementary affidavit at this distant point of time. After, Lord, the arguments are completed and Lord, he is giving his reply can't be accepted. Let me, Lord, address that point first.
But that point has been raised at the time of filing. Your lordship passed an order. This order has not been challenged. That order has not been challenged. When your lordship allow me to file my supplementary affidavit.
For acceptance of supplementary affidavit and the documents annexed thereto are kept open to be decided at the time of final hearing of the writ petition. It was kept open.
Yes. Just I show your lordship what document I have annexed. Can I take up my supplementary affidavit? I shall give reply to my learned senior friend. Definitely, he will be given an opportunity.
I can't take a point of maintainability once this is taken on record. This is at the stage of admission of this document. So, my lord, I had made my submissions on the merits. I don't want to intend, my lord, repeating what I have said. I just want to take a preliminary objection whether, my lord, at this distant point of time, after my submission is over and he is at the reply stage, my lord, a supplementary affidavit can be entertained. Whatever document he has annexed, my lord, may have annexed, but my lord, whether this supplementary affidavit can be accepted. But there is a judgment of your lordship's coordinate bench on exactly the same point. I just want to rely on that and Lord take a point that this can't be accepted at this stage, because this goes against the tenets of pleadings for all times to come. Because once a writ petition is filed, your lordship's Lord calls for pleadings. Then that pleadings gets completed after the reply is filed. Then Lord, he has to explain why, Lord, these documents could not be annexed, etc. This can't go on, Lord. The pleadings can't go on, Lord, till the wee hours of the argument being concluded. So, my lord, if my lord permits, my lord, I cite the judgment and or whatever way my objection is that kindly do not take this into account, because it enlarges the scope of, Lord, the adjudication. It enlarges the scope of adjudication.
But I have filed this supplementary affidavit only to the reasons. A wrong submission has been submitted by the respondents before your lordship, only to mislead the court. To avoid the same, to give the correct answer, I have annexed 2 documents. If your lordship allow me to place those documents and things fit that it is accepted, or give him opportunity to make any further submission, so far this part is concerned, I have nothing to say.
No, whether this document was referred either in the pleading or any of the document annexed to the writ petition,
Absolutely.
or
Absolutely. What I am saying, my lord, I have annexed a document showing that I have been promoted to the post of XYZ. There is a sentence or word officiating. In all promotions, in all of our high courts, the same word is being used. My learned senior friend submitted before your lordship. This is
it was not a promotional post.
This is a special promotion. It is not normal promotion. It cannot be taken note of. I have annexed 2-3 documents showing in all promotions, this officiating term is being used by the High Court. This is a wrong submission only to mislead the Honorable Court. The submission has been advanced on behalf of the High Court. Kindly take note of 2 documents.
The objection that I took, or my submission, was based on the affidavit that I filed. That affidavit was on record. Our case was that this was a special privilege extended to a few chosen because of the nature of the duty that one discharges. I have made my submissions on that. The stand that was taken on affidavit. It was not a new point that I argued. It is there already on affidavit. He has filed a reply. So why should he go on getting a chance to multiply the documents and take a stand which is contrary to his earlier stand? He is now trying to improve his case by filing a supplementary affidavit. Whether that is permissible, in unlaw.
As per leave granted by the court, my lord, he has also used an opposition.
Okay, so if your submission or your argument, whether it would be ultimately accepted or not, that is up to the court. Your submission is that use of word officiating will not determine the character of the post.
I'm grateful to your lordship. Absolutely.
Okay.
Yes.
This issue shall be addressed.
Yes.
Even if the court does not take note of this document, this issue, whether the use of the word can determine the character of the post. Yes, I am writing. Use of the word officiating will not determine the character of the. It is your submission. It would be dealt with. Character of the post or status of the post, whatever be. Status of the post. In all promotional order,
officiating
The
court.
word officiating is used by the High Court.
This stand is not taken earlier. This is for the first time raised in the supplementary affidavit. Lord, if your lordship permits, Lord, I just hand up the
Okay.
of the coordinate bench.
Give
Lord,
it.
kindly come to paragraph 5, page 5, sorry.
Yes.
কপি দে ওকে একটা আছে আমারটা দিয়ে দিচ্ছি আমার এক সেকেন্ড আমি পড়ে নি দিয়ে দিচ্ছি Lord, kindly see the pleading starts at Lord, the issue starts at page 4, bottom.
Yes.
Says Mr. Mitro, learned senior counsel representing a respondent contains that the affidavits cannot be accepted at such belated stage when the original.
Affidavit is supplementary affidavit.
Yes, this is supplementary affidavit.
Yes.
Kindly come to page 5. Your lordships will see the issue has been summarized by the court. Kindly see the second last paragraph. Heard the learned advocate for the parties on the issue of acceptance of the supplementary affidavit and peruse the materials placed. And then, Lord, page 8 onwards, my lord will find the finding of the court, page 8 onwards, after taking note of the case made out by the writ petition. Then, Lord, various judgments are noted. Supreme Court judgments are noted. Then, Lord, the analysis of the documents are at page 10. The delay in obtaining the screenshots of the documents available in the public domain has not been explained in the second affidavit. This is exactly the situation. He is relying on a public document. He has not explained why there was a delay. It is also not the case of the added petitioner that those were produced and relied upon by them before the adjudicating authority. This court is therefore not inclined to allow the added petitioner to bring on record the said document. That apart from the facts pleaded in the supplementary affidavit be allowed to be brought on record would ultimately result in enlarging the scope of the writ petition, which is impermissible, and this court has to exercise its judicial power of judicial review of a decision taken by the authority. KMC, this court further holds that the prayer for added writ petitioner number 2324 for leave to bring on record of documents by a supplementary affidavit after commencement of hearing of the writ petition was only for the purpose of suance. Here, Lord, also
the coordinate bench refused to accept such
correct
supplementary
affidavit and
affidavit or subsequent document on the three count. Delay.
Correct.
It can enlarge the scope of the writ petition.
Right.
And court concluded that it was filed with a purpose to delay the disposal of the writ petition.
The third is the third point is your lordship will find at page 11.
Yes.
In discussing a Supreme Court judgment, the court records that if cogent reasons are assigned for not filing documents along with written statement, leave to produce the documents subsequently can be allowed. However, in the said report case, leave was sought for and when the suit was posted for evidence, long prior to the stage of arguments. But here, argument is complete. My learned friend's initial argument was complete. My argument was complete. And Lord, it is at the stage of reply that the supplementary affidavit has come. And your lordships will find, Lord, then the other Supreme Court case is discussed. Sardar Amarjit Singh Kalra, that is, Lord, page 11. And then it says that
Amarjit Singh Kalra most probably regarding amendment.
No, this is Rani Kusum. Amarjit Singh Kalra, your lordship kindly gives me 1 minute. It is discussed here. Jagdish Pandey, Rani Kusum is discussed in page 10, Order 8 Rule 10. Jagdish Singh Kalra, I think the court has discussed it. Kindly give me 1 minute. Yes, that is page 5.
Yes.
Rani Kusum, Sadar Amrit Singh Kalra.
Yes.
These are the judgments.
Yes.
This is, my lord, on the question of procedural technical violation should not stand in the way. My lord, there are threefold submissions which I want to make, my lord, on the admission of this supplementary affidavit.
Yes.
Lord, first is that, Lord, these documents were available in the public domain. So, Lord, if my learned friend wanted, he could have got these documents, Lord, at the stage of filing of the writ petition. My second submission is that in the affidavit in opposition, a clear stand was taken by the High Court administration. Even at that stage, Lord, if he wanted to procure these documents, he could have. He did not. He chose to sit tight only till his stage for reply came. So, Lord, my humble submission is he has missed the bus long ago. Kindly do not enlarge, Lord, the scope of adjudication, because then again, Lord, another set of arguments will be required to be heard by your lordship on these documents. He either succeeds, Lord, on the basis of his writ petition and the reply that he has filed, or he doesn't succeed. Lord, these are my submissions. I say that, humbly submit that, Lord, the supplementary affidavit should not be looked into.
Looked into.
Yes. My first submission would be they have already used and replied to my supplementary affidavit. So, existence of supplementary affidavit has been accepted by them by filing their reply.
Maintainability of the issue is kept open by the court.
First,
Court acceptance.
it appears, my lord, the court's intent, the High Court intends so that the judge can proceed with a wrong statement. A defective order will be passed by your lordship if my supplementary affidavit is not considered. Fact remains, all appointments officiating, including our appointment, submission advanced on behalf of the bar, also in the supplementary affidavit in opposition. No, these are the only promotions which have been given to the writ petitioners as officiating. Now the stand of the High Court, yes, High Court will proceed on the basis of the wrong statement, wrong submission. And there will be a defective order. To cure the defect, any party can anytime bring any document before court of law.
Yes.
Court cannot be forced to proceed on the basis of a wrong submission on behalf of the bar. To rectify such wrong, again I am repeating, each of the parties is entitled to bring some documents to show that this is not a correct statement, correct state of affairs.
Yes.
And they have used and replied to my supplementary affidavit also. So they have made out their case in the reply, so far my supplementary affidavit is concerned. Within the four corners of that reply, they may make their submission.
Yes.
Now I shall invite your lordship to show, just to show that documents. What is the document? At page 6, my lord, of my supplementary affidavit.
Yes. I'm just here, but this matter would be decided.
Yes, your lordship will decide.
Only the appointment.
Appointment orders.
Okay.
Joint common appointment orders with 4, 5, 6.
The word officiating has been
Same
used.
language, so far the pay scale is concerned, pay band is concerned, officiating is concerned, same language. Verbatim, at least 15 promotions orders. Common orders, at least 10 to 12% has been promoted in other posts.
Yes.
So if the document is relevant, then court cannot shut his eyes. Otherwise, court will proceed on the basis of a defective submission and there will be a product of defective judgment.
Yes.
So far my supplementary affidavit is concerned, my lord, annexure page 6 is one of the joint common order. Same language, verbatim, and page 9 onwards.
Yes.
These are the orders.
Only for the purpose of.
So far the officiating is concerned.
The word officiating has been used.
In all promotions.
In all orders.
Employees, officers, all.
All. Yes.
Submission of the High Court, it is not only for these three people.
Yes.
Now, my lord, so far the officiating part is concerned, these are my submission. So far the delay is concerned, I have submitted before your lordship.
Submitted that unless the
Petition list is published and revised, I am not in a position to know. So far the non-joinder of parties is concerned, the same submission, non-joinder, the third point.
Yes.
Raised by my learned senior friend.
Non-joinder of necessary parties.
Unless the same submission, unless the name of the promotees is published, gradation list is not published, I am not in a position to know who has superseded me, to whom I shall make party. Only from the gradation list I can know that these are the people who have superseded me. Admittedly, they have not denied that at least from 2018 there is no gradation list, no revised gradation list. So, question of making any employee as party respondents only does arise had I been intimated or I had knowledge that these are the people who has superseded me.
Yes.
Your Lordship,
So, since the gradation list had not been published, there was no scope to identify who will be the necessary party. Yes.
Now, Your Lordship, kindly take up page 49 just for a moment. My last submission, so far the petition is concerned. Page 49 is the
of your writ petition.
Writ petition, page 49.
Yes.
Of writ petition number 1. How and which manner it has been given. Your Lordship, kindly come to the bottom.
Yes.
Of petition. Initially, I was lower division assistant, then promoted to the post of upper division assistant, then superintendent protocol, then cashier, accountant. Kindly stop, my lord, superintendent protocol. The superintendent protocol, I have been promoted, I have shown your lordship the promotional order. Employees who have been promoted to the post of superintendent, much after my promotion, they have been given promotion before me in other posts. That's my case. Kindly take note of, my lord, this superintendent promotion, which I have been given on 30th July 2018. All the writ petitioners have been given promotion to this post of superintendent on 30th July 2018. My case is that employees who have been promoted to the post of superintendent in 2019, 2018, they have been given promotion prior to me in the next post. The rule says date of promotion would be the consideration for next post of promotion. Rule 6.2. Now kindly see, my lord, cashier, section officer, additional court officer, superintendent grade 1, assistant court officer. Now I am an assistant court officer. I found the person who has been given superintendent post much later than me, they have reached this post much earlier to me. And in the next promotional post, the moment list has been published, that they are the eligible candidate according to the seniority, I found my name is not there. But the name of the others have been appearing in the said list who are much junior to me from the post of superintendent. The moment I came to learn, I made my grievances. Now, your lordship, kindly see the next page. It is the petition number 2. Same from lower division to upper division, then superintendent protocol, Then now I am assistant court officer.
Yes, yes.
The next post is assistant registrar. Junior will reach to that post. And third one is my lord, the petition number 3. He now reached to section officer up to. He is not even given other promotion, but his junior has been given. He is now section officer. Now, the judgment which has been relied by my learned senior friend. First judgment, 1984, volume 4 Supreme Court cases, page 251. Kindly take note of 1984, volume 4 Supreme Court cases. That is file.
Yes,
they have handed over. Page 251, paragraph 28 and 50 has been relied on.
Yes, paragraph 28, yes.
Paragraph 28 and 50. Kindly turn to paragraph 28 at page 288. Page 288. Bottom portion, paragraph, no, page 50, paragraph. It is, sorry, my lord, first paragraph I am giving, my lord. Page, my lord, 273, sorry, my lord, page 273. Paragraph 28.
Paragraph 28, yes.
May I read, my lord? The real question before us, therefore, is the correctness of the decision of the High Court in the Sang case. Before we address ourselves to this question, we would like to point out that the writ petition filed by the Sang suffered from two serious, though not incurable, defects. The first defect was that of the non-joinder of necessary parties. The only respondents to the Sang's petition were the state of Uttar Pradesh and the concerned officer. Those who are vitally concerned, kindly take note of vitally. Those who are vitally concerned, namely the reserve poll teachers, were not made parties, not even by joining some of them in a representative capacity, considering that the number was so large for all them to be joined individually as responsible. The matter therefore come to the decided with this absence. High Court ought not to decide a writ petition under Article 226 of Constitution of India without the person who would be vitally affected by its judgment being before the representative so and so. Kindly turn the page.
Yes.
And had the petitioner refused to do so, then kindly turn to my lord, paragraph 50 at page 288. Vitally affected. Paragraph 50.
Yes.
51. The summarize our conclusions, a High Court ought not to hear and dispose of a writ petition under Article 226 of the Constitution of India without the persons who would be vitally affected by its judgment being before an respondents or in the list, now some of them being before so and so. Then next paragraph. The Allahabad High Court ought not to have proceeded to the so and so, whatever so and so, without insisting upon the reserved pool teachers being made respondents to the writ petition, or at least some of them being the so and so. Now, your lordship, kindly see the what is the case made in the before the Supreme Court. Kindly turn to page 258. 258. The facts of the case. Your lordship did not make to submission that each and every case ratio decided on the basis of their facts. Last 4 lines of the first paragraph. The subsidiary question being whether the termination of services of the appellant and petitioner as secondary school teachers and intermediate college teachers, although so and so judgment is valid, and if the so and so. By virtue of the judgment delivered by the High Court, the existing post of teachers and non-teaching college teachers have been terminated. In their post, the writ petitioner have been allowed to join. Vitally.
So
in our case,
distinguishable on fact.
Absolutely. Our case is that we are not praying for demotion of any officers. We are praying only inter-se seniority. So none will be prejudiced. The Supreme Court time and again held vitally. Because vitally after 10 years, 15 years service, their service is going to be terminated by virtue of an order. But the person concerned whose service is going to be terminated, they were not made party. Absolutely different point. I am not praying demotion of any employees, not even demotion. I am paying for my inter-se seniority, fixation of my pay scale. None will be prejudiced. Question of vital affected event does not arise at all. Next one.
Yes.
The next judgment which has been placed before your lordship, 1988, volume 4 Supreme Court cases, page 534.
Yes. Paragraph
Only
13.
paragraph relying on paragraph 13.
13, yes.
At page 542. Now, kindly read my paragraph 13. Bottom portion.
Yes.
As has been already noticed, although the point as to proposal by the state was pleaded in the writ petition before the High Court, as an assistant point law, there was no reference to any material in support thereof or so and so. Before us also a practical reason, not facts have been given in the special writ petition or in the writ petition or in any affidavit, but the point was sought to be substantiated in the time of hearing. Well, the submission possibly, my lord, that I don't know why this judgment has been relied upon. Whether any submission has been advanced on behalf of the petitioner, which is not recorded in the writ petition, or supporting documents have not been given. So far, my supplementary affidavit is concerned, that arises only on the basis of the submission advanced on behalf of the court. This is not a case, I have argued the case, which has not been pleaded in my writ petition.
Yes. No argument beyond pleading.
Beyond pleading. The next judgment, my learned senior judge has been placed, 2004, volume 2, Supreme Court cases. Page 76.
Page 27, para 27.
27. So, kindly come to para 27 at page 86. I'm reading my para 27. Your lordship at page
27, yes.
It is true that the order of promotion was in question in writ petition number so and so at the instance of one Ashok, but even in the said writ petition, the promoters were not implicated as parties. As in the case of the association, even in the writ petition filed by the Ashok, the order of reservation passed by the Union of India or NABARD or the sponsor bank had not been questioned. Admittedly, the Union of India and NABARD were not practiced in the said writ petition, not parties in the said writ petition. An order issued against a person without implementing him as a party and without giving him an opportunity of hearing must be held to be bad in law. The appellants herein, keeping in view the fact that the reasons of the ensuing direction, the orders of promotion effected in their favor had been directed to be withdrawn indisputably where necessary parties in the so and so. The issue is that I shall be given promotion in their place. They will be demoted. Vitally affected. Again, I am repeating, I am not praying any relief against my colleagues. Their promotion will be there. Their pay scale will be there. Only inter-se seniority and fixation of my pay scale. All the judgment says if a person's service is terminated by virtue of a court order, he should be party. If a promotion of a person is cancelled, withdrawn, vitally affected, in that case, he should be made party. It is not the case. According to my understanding, nothing, no implication of those judgments so far my case is concerned. The last judgment, another judgment, 2011, volume 9, Supreme Court cases, page 65. Two paragraphs
Yes.
have been.
Para 23, 24.
My lord.
It is also same, non-joinder of necessary party. Yes.
Same. So I'm not.
Same submission, yes.
And another judgment, 2018, volume 5, Supreme Court cases, page 798, paragraph 8 to 10. Delay.
Paragraph 9 and onwards.
My lord. May I
Yes,
read my
delay.
just. Kindly read my paragraph 9, the quotation portion of the judgment which has been relied upon.
Yes.
A person aggrieved by an order of promotion, promoting a junior over his head should be approach the court at least within 6 months or the less so and so. In this case also, my lord, case where that if I given promotion, the person concerned whom I not made party, his promotion will go. And in that case, delay is fatal because interest of someone else is affected. Supreme Court says, due to delay, the promotion which has already been given, it cannot be cancelled.
Yes.
I know, my lord, that at the time of reply, I cannot rely upon any judgment. But if you lordship allow me, definitely my senior man will be given an opportunity. One judgment so far this delay is concerned. Only to distinguish this judgment. One paragraph. I shall read if Mr. my learned senior man is desired to distinguish the same.
Okay, never-ending process. To counter that, I can cite one or
So
two.
far, yes, I am not standing on the. I cannot.
So the hearing could not be concluded today.
Just a judgment which says, my lord, even 30 years delay is followed if there is a palpably wrong. Reporting the policy. 2013, volume 1, Supreme Court cases, page 353. The only judgment 2013, 1, Supreme Court cases, page 353. Because this is only for distinguished 2013, volume 1, Supreme Court cases, page 353, paragraph 13.
So delay of 30 years was condoned by the High Court.
If there is a huge illegality, my case is that by way of not giving promotion timely to my clients and by way of not publishing gradation list, illegality has been committed. In that case, delay is not at all a ground.
Tukaram Kanai Joshi.
Yes.
Whether it was stated that it continued, Tukaram.
Recurring laws. That has also been
yes, continued court of action. That judgment, Tukaram, and there is another judgment.
That is all another judgment.
Non-payment of service benefits.
Pension. Recurring laws. Each and every day facing.
Yes.
Each and every day. But in this case also, to some extent, we are facing recurring loss each and every month. So far the salary is concerned.
Yes. Got the principle. Actually, the principle, Mr. Court is recurring, continuing cause of action.
Recurring cause of action.
Continuing by recurring cause.
Was principally on Article 300 capital A.
300 capital A. Proprietary right. No, I am talking about that judgment, that the non-payment of service benefits or non-payment of salary benefits.
Recurring loss has also been
continuing. I cannot recollect that judgment.
There are numbers of judgment, but this one has also been dealt with in this judgment.
Oh.
Recurring loss.
Yes.
I am getting lesser salary. My pension has been withheld. Each and every month I am entitled to get my pension. After 30 years, on that month also I am entitled to. That has been dealt with. If there is a recurring loss, no delay.
Yes.
Paragraph 14 and 15. I'm sorry, my lord. I am handing over if my learned senior. Paragraph 14 and 15.
Yes. I am.
Paragraph 15, my lord, categorically held even 30 years.
Yes.
And also it is a service matter.
Yes.
But these are my submissions.
Okay.
Lord, to look into these documents, first, Lord, look into his own document, page 37. Because today, his submission is that I have been given promotion on that day. Apart from the word officiating, kindly, my lord, come down. Your lordships will find the expressions are purely temporary basis until further orders.
Yes, I have seen.
And Lord, the same expression is used for the other person.
Yes.
So, Lord, he has to show that he was confirmed in a promotion post earlier than the persons against whom he is seeking seniority. And my learned friend says that I am not upsetting anybody's promotion. Kindly see his prayers. Prayer A and B.
Yes.
A and B. He is asking for retrospective promotion from 2018. And he says, I don't know who are there, therefore I can't make them parties. But he is saying his seniority should be restored in the superintendent grade 2 from 30th July 2018. And then subsequent in the other grade, superintendent grade 1. That is prayer B. So, my lord, if his seniority has to be restored, obviously it has to be affecting somebody else's seniority. He has to be made a party. And that is my case for non-joinder. Kindly see prayer A and B. There he wants retrospective revision of inter-se seniority. And also promotion to the promotional post. So, my lord, today he is not only going to upset the existing employees in gaining seniority, but he is also asking for promotion. This is one, and if his deprivation started in 2018, he has to explain why he came in 2024. His deprivation, according to him, started in 2018 because he is asking retrospective inter-se seniority from 2018.
Yes.
So, blood on both counts, non-joinder and delay, this was my point. Now, Lord, kindly have a look at this other documents. Whether, Lord, this throws any light on his case. Supplementary affidavit, please take page 6. Lord, I skip one because, Lord, the first one, your Lordship kindly sees, this is, Lord, I do hereby appoint Shimonto Kumar Bandopadhyay, Superintendent, Grade 1. Has your Lordship found that? Presently born in interim pay, etc. In the pay matrix of the other allowance, relevant rules on purely temporary basis until further orders, etc. on the 65 post of assistant court officer, etc.
Page 6.
Page 6, your Lordship kindly sees. First, the first one. There are several appointment orders. Kindly take the first one.
Yes.
Kindly take the first one. In exercise of power delegated to me by the Honorable Chief Justice of His Lordship's order dated such and such, in pursuance of the order of the Honorable Chief Justice, I do hereby appoint Sri Simonto Kumar Bandopadhyay, Superintendent, Grade 1, presently born in the interim revised scale, etc. in pay band such and such, to officiate in post of Assistant Court Officer on promotion in the interim revised, etc. on purely temporary basis until further orders. Now, Lord, what is happening is that this gentleman has been appointed as a purely temporary basis until further orders. Now, Lord, the question is that when he has been confirmed, it's not a question of appointing somebody on a temporary basis until further orders. But it is a question when he is confirmed to that post. That will count his seniority. And Lord, similarly, your Lordships will find 2, 3, they are all on same lines. Appointment to officiate on promotion, purely temporary basis until further orders.
Yes.
Now, Lord, how does it advance his case? I really don't understand. Because it is not his case that I was confirmed before these people were confirmed. That is not his case. He is saying that same nature of order is also passed in respect of some other. That clearly shows that the trend and the practice. That if you are not confirmed in a post, you are posted temporarily until further orders. And that is exactly what I submitted at the first instance, that this is a special privilege which is extended. But then if you are not getting confirmed in the post, then where is the question of your getting seniority other than the others? And this is, you have allowed this to continue from 2018, at least, because up to 2018 you have no grievance. You are seeking to go back, turn the clock back till 2018. Now, how do you do it in 2024 or 23 when you come to court? Can that be done? Number one, whether this exercise can be at all undertaken in judicial review. This is the first point, because you don't make anybody party. You say, how do I know? And you say that you want to go back to grade 2, superintendent grade 2 in 2018. You do not know who are your colleagues and who, against whom you are asking for fixing of seniority. Then it is a worse case, because you do not know yourself who are senior to you or junior to you. I really don't want to answer that point, because that really destroys his case. He doesn't know who are his seniors and who are his juniors. And your lordships will find that this supplementary affidavit, whatever documents, my lord, is annexed, they are on the same terms. Any one your lordship wants to take.
Yes.
Lord, your lordships will find page 9 also, same expressions are used. In respect of the persons who are appointed on a post on a temporary basis, the same expressions are used. There is no exception that somebody is treated differently than him.
That's all?
That's deeply obliged.
আসুন মিস্টার আসুন হ্যাঁ
Lord, I don't want to, Lord, add anything. Your lordships will find the first principle was that, if I may just place that paragraph my learned friend was relying, paragraph 14. It says no hard and fast rule can be laid down as to when the High Court should refuse exercise its jurisdiction in favor of a party who moves it after considerable delay and is otherwise guilty of laches. Discretion must be exercised judiciously and reasonably. In the event that the claim made by the applicant is legally sustainable, delay should be condoned.
Like this.
Just a minute. In other words, where the circumstances justifying the conduct exist, the illegality which is manifest cannot be sustained on the sole ground of laches. When substantial justice and technical consideration are pitted against each other, the cause of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in the injustice. Now, my lord, here third party rights are involved. Here, my lord, no third party right was involved. Here the third party right is involved. There is a vested right. And the persons who have a vested right, they have not been impleaded. And therefore, my lord, the line of judgments that I have cited.
Yes, আচ্ছা Mr. Saharal and a senior advocate representing the petitioner and Mr. Call.
Now, my lord, he says that under UCP 500, he has shown you lordship this regulation. If in terms of the letter of credit, the correct matching documents are sent to me, I am bound to make payment. And if within 5 days of receiving that, my lord, negotiating documents, I do not raise any discrepancy, then I am
Bound to honor.
Bound to honor and precluded not to raise any discrepancy ever.
Any letter.
My lord, if I may. My lord, I have been instructed by Mr. Thakkar. He's praying for not today, my lord. Last day he finished his argument, but he is stating that he needs to speak a little more. So
That I am not.
He wants to conclude his argument first, and then my learned senior friend.
Very well, very well. I'm just indicating.
Okay, not today. So any order is to be passed.
Otherwise, my lord, I will not be able to justify since 2 o'clock I'm waiting.
Okay. Yeah, लिखित in heard the learned advocate appearing for the respective party, list the matter for further consideration. Next file Thursday করে দিন।
Let it, but some time may be given since your lordship they are praying for time because the bank manager who was supposed to give me instruction, but he has been replaced and a new bank manager has come. I have asked him some queries. He needs
chair is not changed. Man is changed.
no, this is on document.
Chair is there.
Yes, but these
As and when he will take charge over the charge, he will take all the responsibility.
But he has to go through the records himself. He has joined recently. Some not much. I am saying 10 days. Give me 10.
10 days. He is seeking 10 days.
He is seeking time. So I am seeking 10 days.
আজ কত তারিখ জানো? Okay, 31st. 31st. Release the matter for further consideration 31st July. Yes, next or 6 5 3 matters. Item 3, who is for item 3? Will you take time?
Lordship, I'm led by Senior Advocate Shakhus, and he's not here, Your Lordship. Kindly makes it not today.
Only not today. Achha, not today. Item 4.
Your Lordship, Mr. Abhutosh Majumdar is leading, Your Lordship. He's praying for not today, Your Lordship.
My lord, I appear for the respondent. Last time also, my lord, they took time, my lord.
Mr. Majumdar is having difficulty. Even another matter has been placed after.
In July, there is a difficulty.
24th July, he's not available.
Actually, the matter is.
Okay, 31st July.
My lord, kindly record it.
Acha. Hard, what is your name?
Joyjeev Medhi.
Acha, owner naam likhe dina. Hard Mr. Such and Such and Mr. Roy. Learned Senior Advocate appearing for the
respondents, all respondents.
All.
My lord.
All respondents. Acha. Respondents, list the matter for further consideration 31st July. Acha, yes, item number 5. 5, do it.
5, my lord, I appear for the respondent. That matter, my lord.
Adjournment.
No, Your Lordship. Mr. Ghosh, he is coming, my lord. Let my senior friend start.
Mr. Ghosh argued.
For the respondent, Lordship.
Mr. Ghosh, Mr. Ghosh argued in the last week, my lord. On the last occasion.
That
exoneration
proceedings matter.
Yes, disciplinary proceedings.
Tap witness.
Yes. Yes.
Tap witness 10,000 rupees.
10,000 rupees.
Yes, sir.
Yes.
10,000 rupees. That matter. Exoneration.
The staff.
Yes. I am the employer. Disciplinary authority is the Coal India Limited. Now, my lord, Coal India. So, let me start.
Whether you will conclude today.
I think, my lord, because after me, my lord, either Coal India will say first or I will say first. Yeah, because
No, they have concluded their
they have concluded their argument. Now it's us. They are.
Okay, 1 minute. So item number 6, who is for the item number 6? Whether you will do it ready or you will take adjournment.
Item no, my lord. I can start. I can start, my lord.
No start. Whether you will conclude today or half done. No. So ask the other. Not today.
Well, let us keep it possible. I'll take instruction from the council whether he can finish up today. Then I can start.
If you conclude today, you will not conclude today. Nothing. Then
just a minute.
What? Item number 6. Whether Mr. Chatterjee, will you conclude today? Who is the other side?
Mr. Vishnu Bhattacharya is leading.
I'm for the state, but answering respondent is the Lordship Indian Institute of Social.
Will you conclude?
Sir, Your Lordship, I am not answering respondent, Your Lordship. Answering respondent is.
Mr. Vishnu Bhattacharya is appearing for the.
I'm fixing it on 24th.
24th.
24th. Come 24th, 24th, it would be
Your Lordship,
concluded.
I am in item number 6. I appeal for the respondents. The
Come on that date.
The advocate on record in this case has undergone a surgery. I am praying for 2 weeks' time.
Oh, 31st.
31st.
Now,
31st. It will be adjourned.
now, my lord, so for 5 is concerned, my lord.
Yes,
so
5
what-
you today conclude?
So we will try to conclude it, my lord. If the time permits, my lord, within time we will conclude.
Yes.
We are ready.
How much you will take?
Some time will be given.
Some time. Be brief.
Half an hour at least, my lord.
Half an hour.
Or half an hour for me, my lord. I don't know CLI, Coal India Limited, CIL. Let him. Yes.
Which we understand from the submissions also last
Tag matter,
Yes.
10,000 rupees,
10,000
criminal and Ramlal judgment.
Ramlal and Maharana Pratap.
Oh, yes, now I can.
Because we have to.
So you clarify, actually what? You
have to
cannot
differentiate.
restrain your temptation to say something before the court. Actually, I could have the learned advocate, I could. You just clarified. He is taking 2 points.
Yes.
Decision is based on no evidence, perverse, and in view of the decision of Ranlal, since in criminal case he has been honorably acquitted.
Yes.
He is also get exoneration from the disciplinary proceeding. These two main points.
Yes, and my lord, the persons who has made the complaint before the CBI.
He has not appeared either before the disciplinary authority or before the court.
That's a part. That's
Was conducting.
That's a part of the second point, my lord. That's
Yes.
a part of the second point.
Yes.
The second point includes everything, whether it is based on evidence or no evidence at all. That's a part.
Now, so to counter this submission,
Yes.
the best submission come from you that sufficient evidence is available on the record.
We have prepared ourselves only on those 2 points.
Yes.
Only on those.
You will
have
counter. Don't take that.
We have to prove that the final.
Actually, one appellate side matter, Mr. Mittal is waiting. He has come from Delhi. I can touch at least.
Then in that event, my lord, your lordship may take it up on any day, my lord, recording an order any day, my lord, recording our presence.
Do you know anyone, Mr. Chakraborty, Tonoy Chakraborty? Junior? Also outside. Outside, Mr. Chakraborty. Okay, otherwise you continue. Yes. Actually, when I have 700 matters, then all are to be briefed.
My lord's determination is the most important, right?
Not important, but many matter. Every day you come and
no, this
force me to include.
It's time consuming. Time consuming. It's time consuming. This determination is time consuming.
Time consuming. I know, but many matter is there, so time will be.
Yes, but in the hearing matter, especially in the
yes. So, Mr. You will say first or
he is the disciplinary authority, Coal India Limited, and I am the employer, Eastern Coalfields Limited.
Oh.
The orders.
So, in the circumstances, it would be better to go directly to the inquiry report. Inquiry report. Inquiry report has discussed the evidence.
My lord, before that, may I just draw my lord's attention to the rules governing which this inquiry was conducted? Amended up to.
Yes, I shall keep it till I sign the order.
My lord, kindly first take note of the charge sheet. My lord, the charge sheet will find at page 39 of. Oh, sorry.
Page 39, yes.
My lord, it starts from page 39. It is dated 19 July 2014.
Yes.
The very first line, in the very first paragraph, my lord will see that the process to hold an inquiry was under Rule 29 of the Conduct, 15 and Appeal Rules 1970.
1970. Yes, yes.
My lord, thereafter, I will draw my lord's attention to the very next page, that is page 40. What the contravention of and what was the misconduct? My lord, kindly, I am skipping over the first paragraph, that is the
Yes, article of charge.
article
Article
of
of
charge, the second paragraph.
Yes, yes.
My lord, kindly note the contravention of the relevant provisions, Rule 4.1 to Rule 4.14.
4, yes.
And my lord, misconduct under Rule 5.01, 5.02, 5.05, 5.020 and 5.026.
Yes.
Now, my lord, kindly take note of the rules which I just handed over. My lord, the first, kindly take note of the Rule 4.1 to 4. My lord will find that at the very beginning at page 17. The page number is indicated at the bottom, my lord.
Bottom or top?
My lord, the top number.
Page 17.
One, in my
17.
bottom, 17. My lord, the same, I believe, the same document.
তলায় কিছু নেই যেহেতু তলায় কিছু নেই
My lord, kindly take my copy. My lord, kindly mark the
yes
the of Rule 4.
Rule 1 I
Rule 1 to 4.1.
আচ্ছা fail to maintain absolute integrity.
My lord.
আচ্ছা fail to show his division আচ্ছা devotion to duty. Okay, আচ্ছা.
My lord, after that,
To act in a such a manner, yes.
My lord, this is under the duties and obligation which an executive has to follow.
Yes.
My lord, now kindly come to misconduct. The very next.
5.
My lord, he has been the committed misconduct under
for
5.01
in connection with business and property of the company, property of another person within
the premises of the company, taking or giving bribes or illegal gratification.
Yes.
My lord, then 5.05, acting in a manner prejudicial to the interest or
of the image of the company, and
my lord, thereafter 20, commission of any act.
Yes, got it.
Discipline of good behavior, and 26. My lord, these were the charges which were brought against him. Now, how he responded to those charges? My lord will find the response at page 44.
44
of the writ petition.
Statement of defense.
My lord, statement of defense. It is one dated of 10th January 2015. The date, my lord, page 45 below his signature.
Yes.
My lord, kindly take, I will only draw my lord's attention to paragraph 2 and 3 and also 4. That all the charges which have been leveled against me in this case of memorandum, Annexure 1 and Annexure 2, as well as in the FIR lodged by the complainant, are entirely false, fabricated, such and such. There is no iota of truth inviting therein. I am totally innocent. And last line. Hence, I clearly and categorically deny all the charges leveled against me in your aforesaid mentioned memorandum. My lord, thereafter, that, sir, my original case in connection with the matter is pending before the Special Judge CBI Court, Asansol, for proper adjudication. And as per elementary rule of natural justice, a person cannot be tried, examined twice for the same offence. Last, my lord, he prayed for. Hence, under the above facts and circumstances, it is requested to set aside, adjourn the entire proceedings till the judgment of this case by the Honorable CBI Court, Asansol. Why I relied upon this, my lord? So there was no allegation of vague or ambiguous charges. Such allegation was made. He merely simpliciter denied the charges and prayed for that till the criminal proceeding is does not end, kindly do not proceed. My lord, what happened after that? My lord, after that he filed a writ petition. I believe they have taken my lord to that attention to that order. That is at page 132.
130.
132 of the writ petition itself. My lord, if it is in two volumes, it will be most likely in the second volume. The first one. 132.
Yes.
My lord, here why I will be taking note, my lord's attention to this judgment because of the third paragraph, my lord.
Yes.
My lord, kindly note the date of the order, 17 September 2015. My lord, I will directly draw my lord's attention to third paragraph. Even a bare perusal of the report in the form of affidavit reveals that in respect of the disciplinary proceeding, which was initiated more than 1 year ago, that is such and such, the writ petitioner never appeared before the inquiry officer, except for one occasion, even though various dates were fixed for conducting the inquiry. My lord, now kindly take note of, so my lord, he never appeared till that date, except on one occasion. My lord, 133. My lord, again, the last paragraph, fifth line. Rather, my lord has got the word
Rather.
Rather, the writ petition reveals that the petitioner had no intention of participating in the inquiry proceeding, which will clearly be evident from paragraph 11 of the writ petition, where the petitioner stated that he made a representation to the chairman. But that is the representation we relied upon at page 44. That is his statement of defense come representation. Now kindly take note of this order was passed, his writ petition was dismissed. Challenging that order, he preferred an appeal. My lord will find the order of the appellate court the very next page at 135. It is an order dated 11th November 2015, my lord. At the top, left hand side. Here the court said to the authorities to consider his representation and pass a reasoned order.
Another, he preferred appeal.
He preferred an appeal challenging this order, which
Yes,
I quote right now, madam. The
Oh.
order of 17th September 2000.
136.
Yes, madam. 1601, 135 is charge form. My lord, the relevant portion is 136.
So disciplinary authority may pass appropriate order in accordance with law after affording an opportunity of hearing.
My lord, the proceeding was stayed.
Proceeding was stayed.
Disciplinary proceeding was not proceeded.
Yes, yes.
Now, my lord, kindly take note of, as has fallen from the very first instance, my lord, the procedure. Now I will draw my lord's attention to the procedure by which a disciplinary proceeding has to be conducted in the bank, in the coal India.
No, he is not claiming that there is procedural irregularity.
If he is not claiming any procedural irregularity, one of the ground where a court can interfere, my lord already knows, if the decision-making process, that is the procedure.
It is well settled, very well old proposition of law. But if the decision is perverse,
My lord,
the scope will be extended.
My lord,
Okay.
perversity has to be shown. In this regard, before starting with the inquiry report, may I just indicate a judgment wherein the perversity, what are the grounds on which it can be constituted to be a perversity, has been stated. ওই judgment সুব্রত নাথ 2022 SSC online SC 161 22 SSC আমার পক্ষে 1617. My lord, kindly take note of first.
Your respondent number?
I am 1.
1.
1 to 3. Coal India.
Paragraph?
My lord, first kindly take note of paragraph 13, the issue.
Yes.
The point that arises for our consideration is whether in the given facts of the case, the learned single judge and the division bench ought to have interfered with the punishment imposed on the respondent by the disciplinary and upheld by the appellate authority as well as by the revision. My lord, thereafter, kindly take note of paragraph from paragraph 14 to 21. My lord, the parameters has been described at paragraph 18. My lord, now kindly directly I draw my lord's attention to the parameters at paragraph 18. My lord, it will find at page 9 the page number is indicated at the top. My lord, may I read? Paragraph 18. Laying down the broad parameters within which the High Court ought to exercise its powers under Article 226 to 27 of the Constitution of India and matters relating to disciplinary proceedings, a two-judge bench of this court in Union of India versus P. Gunasekaran held thus. Despite
yes.
the well-settled position, it is painfully disturbing to note that the High Court has acted as an appellate authority in the disciplinary proceeding, reappreciating even the evidence before the inquiry officer. The finding on charge 1 was accepted by the
Yes, yes, come to that 12 A, B, C, I.
Yes, my lord.
Gunasekaran judgment. Findings of fact is based on no evidence.
My lord, there.
It is called perversity.
It is the law of perversity, my lord.
Yes.
My lord.
And this question will be question of law.
Question of law. My lord.
Whether the decision is perverse, it is a question of law. Although court is to look into whether there was any evidence or not.
Because otherwise, my lord, then what will be based on no evidence? What is no evidence? My lord, as far as a subject to correction, my lord, no evidence will be, as per my understanding, my lord, some documents or examination from the cross-examination of or cross-examination of witnesses, some relevant facts came to the light of the court, or some written submission was made by the charged officer from which has not been taken note of by the inquiry officer at the time of proving or disproving the charges. In the instant case, my lord, I have very first instance has drawn to the my lord's attention the manner of denial of the charges which were leveled against him. If I can say, my lord, it was a vague denial. There was no particulars in support of the charge, in support on the basis of which such denial to the charges which was made to him was brought to the notice of the inquiry officer. My lord, it has been strongly relied upon to the fact that the complainant was never examined. My lord, fact remained that the complainant expired. Fact remained for 1 year this gentleman never bothered to present himself before the inquiry officer. Such being the conduct of a charged officer, can he take the assistance or plea of no evidence when he himself, where he has conducted himself in a manner which otherwise is detrimental to his own interest? My lord, as rightly pointed out, my lord, we have to look into the inquiry report for the purpose of proving or disproving the case of no evidence. My lord, kindly then take note of page 40.
Conduct is one piece of evidence, one link.
Absolutely, my any evidence that I will rely
Section 8 of the Evidence Act, subsequent conduct, previous conduct, it can be treated as a relevant fact.
My lord, my lord,
if it has some connection with the fact in issue.
My lord,
Okay, relevancy with the fact in issue.
my lord, even all.
My lord, I just stopped. Only conduct. Why that representation is shown? That is the basis of his entire case. Starts from there. Because, my lord, as your lordship knows it very well, the pleadings which are corroborated by evidence. Now, it's his pleadings before the inquiry of it. Here, my lord, nothing is there.
Yet, not that. A disciplinary proceedings is a quasi-criminal. Although degree of proof is preponderance of probability. And like a accused person, he can say that I have a right to remain silent. You have brought this allegation. So primary burden upon you to prove the same. Primary allegation is upon you. You have alleged that I have done such and such misconduct. So burden is upon you.
That burden is on us and we will show it from the inquiry report.
An accused has a right to remain silent. Accused, I shall not give defense witness. You prove it.
The moment, my lord. Yeah,
So in civil case, that he has not made a specific denial, that would be tantamount to admission, is not available in criminal case.
My lord, here, my lord, subject to correction, my lord.
Okay.
It's a quasi-judicial, my lord.
Yes.
Here also, my lord.
Degree of proof preponderance of probability, but burden is totally.
If it is proved at its slightest point
that the charges which are brought, if it is proved at its slightest point, then the owner shifts. I will come to it. Then the owner shifts. Then it's for him. If he remains silent, then he
particularly when both the cases are going on parallelly, a disciplinary proceedings as well as the criminal case. He has a right to say that I shall not participate in the disciplinary proceeding since my defense will be disclosed.
That subject to correction, that cannot come as a right. He may say.
May say.
That's his prerogative. He may
Now-
say, but whether that's why
Now ultimately you accepted Supreme Division Bench has stated.
stay of this disciplinary proceedings which come to the court, in most of the cases, that's not allowed. Why? Unless and until all those conditions, as in the HON'BLE Anthony case and the GM Tank case, are fulfilled, so generally those are not allowed. Stay. Why, my lord? If it had been a right, then it would have been allowed automatically. It's not a right, but he may say. This was not my lord.
There is some judgment, Supreme Court judgment, Supreme Court has.
Two or three judgments wherein all those judgments are referred back.
Okay. So finding of fact is based on no evidence, that is called perverse. The court can extend its scope of judicial review. Admittedly, even P. Gunakaran case also.
What is no evidence?
Gunasekaran.
What is meant by no evidence?
No evidence, yes.
My lord, kindly take, it starts from page 47. At page 48, my lord, there is an index.
Page 47.
47, the inquiry report starts from page 47. At page 48, there is an index.
And hence I directly invited you to come to pay inquiry report.
My lord,
Okay.
My lord, brief.
Such time should have been saved.
No, my lord. For the reasons I was trying to draw my lord's attention to the rules, because
Yes.
at the end of the day, I cannot act beyond the rules.
Yes.
So if I can showcase before my lord that following the rules and procedures, judgment will come.
Yes. Come to page.
Take note of page. My lord has seen page 48. Now kindly take note of point number G.
The brief statement of defense. Oh, you come fast.
My lord, brief statement of defense. My lord, it is at page 50.
Okay, yes, sir.
My lord,
You
kindly
cannot take
note of-
advantage of the weakness of the defense.
My lord,
You so fast how we have proved your case.
my lord, kindly.
Failure of the defense to satisfy their case may be an additional link, but it cannot be the sole basis.
No, my lord, I am taking one by one. My lord, kindly first take note of page 60.
Okay, according to you.
My lord, now kindly take note
Page.
of 63, point number 5.
Yes, G, brief statement of page.
63, my lord.
63.
Yes, that is what it is.
Yes.
Point number 5, he did not cross-examine.
Yes.
My lord, now page 66, what was the point for determination?
Yes.
Now, my lord, from page 67, the reasoning starts. Do I read my?
Yes.
Assessment of the evidence in respect of each one set out for determination and findings thereof. The points for determination as above were examined considering the assessment of evidence and the submission made by and through their brief, the following are the findings. Sri Sumit Dasgupta, PW Inspector CBI Kolkata, giving his evidence before the IA such and such as recorded in the daily order sheet dated such and such. Recorded that he was the investigating officer as well as the trafficking officer in the instant case and made trap on such and such. An amount of such and such was found and recovered from the left pocket of his pant or the trouser by the team of CBI officials and the independent witnesses. The currency note numbers were found identical to that of the numbers already recorded in the pre-trap memorandum. These currency notes were treated with phenolphthalein powder. Sri Dasgupta is deposition on such and such before the IA also mentioned that after the seizure of the currency note, both the hands on one another, both the hands one after another, switch half. The accused were to be clean bowls of water. mixed with sodium carbonate and the color of the water turned into pink. Listed documents and serial number 2 and 3 and at annexure 3 to the memorandum dated such and such are documentary evidence to prove the charges. The conversation between the accused and the complainant were recorded in a video voice recorder, and the translate of the conversation as recorded in the listed document and serial number such and such, read with listed document serial number such and such at annexure 3 such and such are also evidences to prove the charges. Sri Irfan Alam, reported that the witness and the one after one were put in a bowl of water with and the color of the water turned into pink. He further witnessed that on the direction of CBI Swapnil Kumar Paul, and the of the money from the pant of Sija and the currencies were identified, listed document number 3 at annexure such and such. Shri Prabhat Kumar Shah, charge officer, also admitted the fact and recorded in his statement US 11
চক্রবর্তী কি এসছে?
on 6/11/2017 that the currency notes came out that is
You will
taken out
take
of his
time.
left pant pocket. Point number 5. The allegation.
How much you will take?
Not I have to show the inquiry report. Then I will rely upon the documents.
Yeah, after
So I am fixing on the yes. Yes.
because all the points that
আচ্ছা, heard the learned advocate appearing for the respective party leaves the matter for further consideration. আর 24 তারিখে কি করলাম ওটা অনেকগুলো keep it on record.
My lord, we need to get it Xerox.
Yes. Yes, Mr. Chakraborty.
This was fixed 2 months back. That's why I could not remember. It is on Thursday. It was fixed possibly in the month of May. This matter.
Oh.
It was heard in the month of May, possibly. For the vacation.
Oh.
That was a difficult.
Sorry, last matter is সারাদিন চলবে।
আর শুরু তো করি আর জিএসটি বই কোথায়? জিএসটি বই দাও।
However, cannot be taken up, then we can fix another date.
I have had how many days?
Senior friend has argued for some length.
My lord, my arguments is already concluded.
Yes, yes, today they will give reply.
My lord, may I say something? The second matter in today's board, I do not think he can finish the first matter because he will argue, then he will reply. The second matter, another date may be fixed.
Second matter.
Yes. Which was heard yesterday.
Oh. The first matter will be concluded today.
He will conclude. No, no, to me, my lord, by 3:30, I'll try to conclude it. My learned senior friend has argued at length, and my lord, to oppose a stalwart, I have to show the relevant provisions. So I will take some.
I try to conclude.
Lord, I'll do my
at
whatever.
least-
My lord, my difficulty, see, my officer is sitting from the lunch hour because I
Yes.
fine.
Yes.
My lord, the second matter, a date may be fixed because Mr. Mittal is there.
And Mr. Mittal has seen only to take up this matter how I have other matter. Go. Yes.
Second matter, any date may be fixed. The second matter, any date may be
First
fixed.
matter we started, at least it is, I'm
Yes,
sure he
yes.
will conclude.
So second matter,
Any date.
when?
My lord, then it will go.
When you will be available again?
My lord, in sometime in August, my lord, the 13, 14 or 11, 12 August.
11th আছে?
Monday, 12 is Tuesday, my lord.
CLT তে কবে আছে? NCLT তে 11th August. 12th August can be.
Yes, 11th August.
12th August.
12th August. 12th August at 2 p.m. এই লাস্ট ম্যাচটা অর্ডার লিখে নিন তো। ও কোথায় গেলেন?
If it is
এই যে ওরা বুঝতে পারেনি। হ্যাঁ। Okay, I am passing an order. I am fixing on that. ये लिखे निन तो 12 August 2025 at 2 p.m.
My lord, kindly record that my learned friend argument is already concluded.
yes.
Union of India has concluded.
Yes.
Kindly record that.
Yes. It will remain.
No, my lord, at least, and he has already started.
It will remain what he has said is to also will remain. Don't worry. Neither the 73.5 nor 74.5 not antivirus, not mandatory. It is optional. You may not. This submission.
My lord, sometimes it's happened again the argument started. My lord, my just humble.
No. I
kindly maybe recorded since I have already concluded. My lord has recorded. My learned friend has concluded the arguments, and only the state has to argue.
Yes. I am to record it.
Yeah.
Okay, let my officer come. Air code come. Yes, I am recording.
Yes. Come.
এই সময় দ্বিতীয়টা একটা অর্ডার লিখুন তো WPA 5859 51 ওটা 2020 100 আইটেম নাম্বার 100 আপনি এটা লিখুন তো
না
তো এই
in this particular writ petition, the aspects have been checked. Yes. Writ petition, two aspects have been challenged. Principally, two aspects have been argued. One is the authority vis-a-vis my power to inspect under section 67. The jurisdiction has been challenged. And the second one is cross empowerment. I'm just giving a background. My learned senior friend has argued that he being an assessee comes under the exclusive provision, exclusive consideration of central GST, and state GST cannot do it. Any officer of the state GST cannot do it. If my lord sees his prayers, yes. First prayer is page 23, his first prayer. 23 of the writ petition. Of the writ petition. Yes. A writ of declaration, certiorari, mandamus, or any other appropriate writ, order, or direction against the respondents declaring that the state tax officer, that is the respondent number 3 to 6, have no jurisdiction over the petitioner, as the jurisdiction has been assigned to the central tax, which I had said first. Officers by the respondents in decision taken by the GST Council, a constitutional body for which the respondents are members, for which a writ of certiorari, mandamus, any other appropriate writ, orders, direction against the respondent number 3 to C, declaring that the impugned authorization for inspection of search dated so and so issued by respondent number 3 is without search. This is the second point. Inspection of search dated so and so issued by respondent number 3 is without application of mine and illegal, and the entire proceedings initiated by the respondent is number 3 to 6 against the petitioner is illegal under the law. A writ in the nature of certiorari, mandamus, or any other appropriate writ, orders, direction against the respondent number 3 to 6 by declaring that the impugned notice dated 21st December 2019 by email sent by the respondent number 4 for production of documents under rule for 5618 and 57.2 under both CGST Act 2017 and W is beyond the scope of the rules. Arbitrary and ex officio invalid under the rule. Rules are under challenge possibly. I don't know, but and these are the more or less these are the premise. My lord, first, my lord, I'd kindly consider section 67 of the CGST. Yesterday, my lord, when I was arguing, I had shown, my lord, section 61. Yeah. The scrutiny stage. My lord would remember that the scrutiny can lead to different steps. One of the steps is inspection, power of inspection, search and seizure. Well, that matter I'm giving. Yes. It's here. Yes, yes, 67. Because my learned senior friend has argued that my power of inspection is chapter 14. They go for it. Inspection, search, seizure, and arrest. Section 67. Power of inspection, search, and seizure. Where the proper officer, not below the rank of joint commissioner, has reasons to believe that. My learned senior friend has argued at length that there was nothing reflected from my action that they had reason to believe for an inspection. A taxable person has suppressed any transaction relating to supply of goods or services, or both, or the stock of goods in hand, or has claimed input tax credit in excess of his entitlement under this act, or has indulged in contravention of any of the provisions of this act or the rules made thereunder to evade tax under this act. or any person engaged in the business of transporting good, or an owner or operator of a warehouse or a godown or any other place is keeping goods which has escaped payment of tax or has kept his accounts or goods in such a manner as is likely to cause evasion of tax payable under this act, he may authorize in writing any other officer in central tax to inspect any places of business of the taxable person or the persons engaged in the business of transporting goods or the owner or the operator of warehouse or godown of any other place. আমাদের স্টেটেরটা আছে, স্টেটেরটা ওয়েস্ট বেঙ্গলেরটা কোথায়? My lord, here my lord would find officer of central tax in our West Bengal legislation. The word is, I'm showing that, my lord, state tax. My lord, this is parametry. All the clauses except interchangeable. Center becomes state in the state legislature. State GST, my lord, West Bengal GST Act, it becomes a state. This central word, of any other officer of central tax authorization. Now, the first is, so rank of joint commissioner has a reason to believe 1 and 2, then he can authorize. Now, my lord, kindly read this with rule 139. Which is at page 430. Page 430. So this is a central rules.
Yes.
This is 67 in the State Tax Act, just for my learning.
Perimeteria.
West Bengal Act, my lord. This is
Perimeteria.
Private. Perimetry. Also, tender apology. State.
Yes.
Starts from the previous page, my lord, the relevant provision. It starts from page 187. And my lord, what I had shown, he may authorize in writing any other officer of state tax. So that is at page 188. My lord, kindly the A and B, he may authorize in writing any other officer of state tax.
Yes.
This is the state. My lord, my lord, this is my exclusive for the state of West Bengal. I will hand over a copy.
Okay. Yes.
Because, my lord, what happened was we are not having, as lawyers, state lawyers, GST matters, we are not having the book where all the latest amendments were there. So we requested the department to have a book where these amendments are incorporated.
Yes.
Or else it becomes difficult, my lord. Kindly see
Okay.
139.
Yes. From
Rule
this
one-
side.
The rules, my lord, this is central rules.
Yes, central rules. Yes.
Page 43, that is parametry. I'm not showing the rules side by side. It's a parametry. Inspection, search, and seizure. Where the proffered officer not below the rank of a joint commissioner has reasons to believe that a place of business or any other place is to be visited for the purpose of inspection or search, or as the case may be, seizure in accordance with the provisions of section 67, he shall issue an authorization in form GST INS 1 authorizing any other officer subordinate to him to conduct the inspection or search, or as the case may be, seizure of goods, document, books, or things liable for confiscation. Now, my lord, the form is very important because my learned senior friend has argued on this. Minister, Kindly, my lord, one. What of page? $855 one. $855. Yes. This is the form. This is INS1. But this is for, my lord would find, here the word is authorization for inspection or search. The language. Caesar is not there. That is INS2, which my lord would find the next 856 INS2. Caesar is INS2. Yes. 139.1, my lord, this has to be, information has been presented before me. I have reasons to believe these are the things, and thereafter authorization. Now, my lord, my learned senior friend has argued that INS1, which we had issued, which, my lord, I will argue where from he has got this form. I have checked the original. There are some discrepancies with this. My lord, his INS1 is at page 30. Yeah. And I have reason to believe he has said there is no clarity whether this was reason to believe for search or seizure, whether it was for search, but this form INS1 is exclusively for search. And he has said 31, page 31, these of the officers where from this name came, page 31. Yes. But in this regard, first I want to show, well, reasons are not, it can be in the file also. If it is, that's why I've asked the officer to come with the file. Now, this is, I'm relying on a judgment of Division Bench of Delhi High Court on this regard. 2024, 158, volume 158, taxman.com, 226. I would kindly see. Extra copy need to citation পরে পাঠিয়ে দিচ্ছি। I would find the first paragraph. The petitioner has filed the present petition principally challenging the search inspection conducted at his business premises situated at 3460/1 Joymata so and so under section 67(1) of the Delhi Goods and Services Tax Act 2017. The petitioner claims that during the course of such an inspection he was compelled to reverse the input tax so and so amounting to on account of inadmissible ITC and shortage of cash. Now kindly see paragraph 8 of the judgment.
Yes. এই একটা কথা উঠে।
8. The authorization in Form GST INS 1 does not require the concerned officer to give reasons in details. It merely requires that the reasons for which the search/inspection is to be conducted under the statute be mentioned. The detailed reasons are not required to be shared with the taxpayer prior to the search inspection. However, the taxpayer is at liberty to apply for the same and absent any reason to deny the request any reason to deny the request, the same ought to be provided to the taxpayer. If I show the reasons in my file, original file that সকালবেলা যেটা দেখালেন ওটা কোথায়? INS 1.
And my written arguments and only of 2 pages, and that shows what point I have taken.
Yes.
Because this page 30 is totally vague, and I have shown many judgments.
Yes.
After affidavit, etc. Because his argument should be what I have argued.
Let me complete my submission. -1. Kindly see this page and the note sheet. This first tender opinion, this original one. One is 0. You would find there is a specific tick mark also, for which reasons my lord would find has indulged in contravention. My lord would find this tick mark here, INS 1.
Okay, this document was given to him.
My lord, there is nothing on record, my lord, that he has asked for this document. And that's why that is why
Page 30 is already there.
that it doesn't matches. Kindly see, it doesn't matches. The tick mark doesn't matches. So, my lord, someone must have interpolated it, must have xeroxed it in a manner that this tick mark doesn't appear. How can it be, my lord? It is in the original file. That's why I take response. I have asked for, and there is a note sheet also, my lord. I've seen the note sheet, the first page. My lord, there's an entire detail is there, reasons why this inspection was necessary. Entire detail. The scrolls of money, it is stated that there was an input tax, evasion of tax, scrolls of money. Now that is there in the first page. Note sheet. Yes. Kindly see, this is the note sheet. My lord would find the first page.
Yes.
This is my lord would find the details. May I place it? It's very important, my lord.
Yes.
The SSC has been defaulter since August 2019. From our database, it is found that the total net tax liability considering so and so since October 2019 to August 2019 to October 2019 is so and so. The ITC claimed by the SSC from the tax period April 2019 to July 2019 in 3B is rupees so and so, whereas the amount of ITC has been matched with the corresponding GSTR 2A auto-populated, wherein supplier have submitted GSTR is rupees so and so. There is a prima facie reason to believe that the SSC has claimed excess ITC to the tune of rupees 11 crores so and so, which has ultimately reduced the net tax liability to that extent. The services the SSC will be provided as per his declaration in the GSTN portal are management, consultant, maintenance or repair service, renting of immovable property, services, supply of tangible goods for use and work contract services. Neither of the services is exempted. But the SEC has claimed exempted supply of service in every return. The total claim exempted supply since July 2017 to July 2019 to the tune of rupees 369 crores. Therefore, I think there is a prima facie reason to believe the SSC has suppressed the true nature of its supply. In my opinion, it is a fit case for inspection under section 67 of both the CGST and West Bengal GST Act. So when the reasons were there, I had gone to their place and inspected and show the inspection report. I'll show the inspection report. So when as per the judgment which I had shown, if the reasons are found in the file, that is enough. And my lord, kindly see, now matches this INS 1 with page 30. Kindly see, my lord.
You gave this note to the petitioner?
No, my lord, it is
Internal.
Internal, they have to show that they have asked for this. Well, kindly see the Delhi High Court has specific, they have to ask for this. Well, today, if I give them any pre-notice of I am going there, they will always, when they will, what should I say? They will, obviously, the documents which I require.
Remove.
It is already there in the writ petition on page 30. My learned friend has shown it.
But kindly see.
Page 35.
30. Page 30
But kindly see,
there in the writ petition.
my lord, kindly see page 30. I'm grateful to my learned friend. Now, my lord,
he has shown.
Kindly see page 30 now. INS 1 I showed, my lord. Whether it matches with the original INS which is in the file. Kindly see.
My lord, there counter affidavit.
I request my learned senior friend not to disturb me. I have not disturbed.
Disturbing.
No.
If something has to be refuted, I have to. If something is after 5 years, is making an oral statement.
I will not speak
He's making
anything.
an oral statement without any affidavit. Otherwise, his officer will go to jail. He's making a interpolating of these documents after 5 years. He has already filed affidavit. Such a statement, absurd statement, cannot be allowed to be made today after 5 years. What statement he has made? It is interpolated. These documents. He has already filed affidavit 5 years before. Can it be allowed to be? If I say this file is interpolated, he has not shown me these documents. The kind of statement he is making, let this matter go to CBI. I can give my undertaking. This officer will go to jail. What is that? Who has written this? When it was written? And if this document was interpolated, was it not my friend compelled to file an affidavit? Can he make an oral statement today? Such a statement, to my humble submission, can never be allowed at the time of final hearing. If he is saying this document was fabricated and false, he was to give an affidavit. Without any affidavit, what statement? He has already filed an affidavit. Whether he uttered a single word, his affidavit is on record. He has to argue on the basis of this. Mohinder Singh guilt judgments long back. Opto judgment of the Supreme Court I already filed. He cannot be allowed to argue on the facts, which is beyond the pleadings, which is on record. He has filed affidavit, whether he said anything about it. This officer should be questioned. Who has filed this affidavit? My lord, I have my entire experience. Government files are always manipulated. They never paginate. I can show my so many communication with the minister.
Don't generalize government file always manipulated.
In such a cases.
Don't say it.
No, no, in such
You
cases.
past years.
In such cases, when they have filed, my lord, the affidavit.
However, you have not claimed this. You have not asked them to furnish this document.
This document already given by them. How I have placed it? They give it when they come for inspection. It is their signature is the in this. It is not.
Without
That's why they
taking
accepted
any
it.
without taking any receipt from you. They have
always-
charged 100 hours.
Once they come for inspection, even in fact, if they don't give, they file with affidavit. I can show in other cases also pending in this court, other high court. This form is already on record since 2020, my lord.
Okay.
They file an affidavit.
Okay, so allow today most probably it would not be concluded.
Cannot go beyond that.
Do you want to bring these documents on record? I will bring because this is original file and kindly see this page 30 does not have that tick mark, which is important. The reasons to believe does not have the tick mark. How is it possible? How can I have also Xerox it? Kindly see my Xerox copy. Have the tick mark. How is it possible? Well, these are all premised under some technical errors. They do not want the final adjudication process to complete. This is their only endeavor. And Mahinda Singh Gill is opposite. It says affidavit by affidavit you cannot supplement the order. The Mahinda Singh Gill 78th Supreme Court is just the opposite principle is being said. By affidavit you cannot improve on it. But I am saying on the file I have the original documents. I am saying this tick mark is absent. Am I wrong to say this? Am I wrong to show this to the court? When the hearing is taking place, when I am supported by Delhi High Court, the file has to, for my lord, if I would have said in the file I have the reasons, but I would not have asked my officer to come in the court and wait from 2 p.m. to see that, to be present when this matter is being heard. And on the previous occasion, all that occasion, when my turn came, I would ask the officers to come so that I can show the original. First, I have to satisfy. 2020, I was also not present in the panel. I cannot go. But to make this type of submission, government manipulating, why he has said the government has manipulated the documents, let him show the affidavit. But there's a limit to it. This is a chartered high court. But kindly, my lord. But if we all and sundry and coming and in between, but I have not learned. I have worked with all the seniors, both High Court and Supreme Court. I have not seen this type of practices. Kindly fixes that day. Oh, original, there is a tick mark. Yes. Kindly see. But the document which they have produced, there is a no tick mark. Not only tick mark, my lord would find INS, there is also some kind of scribbling. Kindly see. In original. Or kindly see the original. Yes. Scribbling. That is missing there in the Xerox copy. So someone, my lord, at the time of doing Xerox must have done something. Because it is mine is also a Xerox copy. I have Xerox it from the original. Kindly see. Two things are missing.
But they are not showing even today also the documents. I never see such kind of arguments. They will argue like this. They have to show.
My lord, my learned friend will see many things. Signature matches, my lord. Would find the signature matches. I've seen that. Signature matches. Signature? 31 matches. Page 31, the signature matches. So page 30, that is missing. The reasons for inspection. My lord, whether it is a deliberate, my lord, it is also an equitable court. Writ petition is an equitable court. Whether, my lord, this can be allowed or not. I am showing from the original file. My lord, once I'll file a supplementary affidavit annexing this document. My learned friend wants my officer to take responsibility, my officer will take responsibility. अच्छा ये कोई आसन करे So I am inviting a supplementary affidavit from them. Since a dispute on the next day,
My lord, kindly say.
advance copy will be given to your junior.
They have already filed an affidavit, my lord, record kindly things.
But I have brought the original record.
I hear they are not fine. I want to take it on record.
Yes, I am very happy.
Yes.
So that it come.
Yes. I direct them, you bring on.
Yes.
Yes. Stop. আচ্ছা আসুন তো আপনি করুন during the course of hearing Mr. Chakraborty, learned advocate representing the state, submits that there was a sufficient In the meantime,
তুমি তো বলেছো হবে না হবে না।
Well, say
13 August 2 p.m.
yes, my lord, say 1 week in advance so that I have a time to file.
I'll file
1 week in advance. Yes.
An advance copy I have stated.
Yes.
1 week in advance of the next day.
Acha. 1 week in advance. Acha,
Yes.
1 week in advance. Acha. Okay.
Take to the-
Yes.
I'm
কোথায় গেল,
grateful.
কোথায় গেল? Petitioner 1 week in advance.
Compared to mention.
Compared with it.
That is a men-
Before my lord rises, my lord, I was there at the time of mentioning in the morning, my lord, the medical council matter was mentioned by Mr. Sen. That they filed an application for modification of my lord's earlier order. Now, my lord kept it on 20
When it has been kept.
on 23rd. Now what they have done, they have communicated the date to be on 21st to the special officer.
No, this matter was mentioned by Mr. Sen today.
Yes, I was
Thereafter, when it has been fixed. ইয়ে বাবু কবে যেন বললাম ওই সাক্ষ্য সেন মেনশন
on
করলো না
23rd, my lord, if I'm not mistaken, my lord.
একটা ইলেকশন ম্যাটার মেডিকেল কাউন্সিল.
What they are intention, they have to stall the inspection. But today itself, inspection has not been due to receiving of such letter. They communicate that your lordships, as if your lordship stall the proceeding, and it should be listed on 21st. But she said it is listed on 23rd.
But initially, my lord wanted to keep it on 21st. Thereafter, it was kept on 23rd. Now, they have intimated the, they have communicated first. But kindly keeps it on, this is on wrong communication of dates, my lord. They have communicated the date as 21st instead of 23rd. Now, what they are trying to do is, they are, I'm led by Mr. Chatterjee. my lord.
21st.
So the special officer can't stall, my lord, whatever is happening. It was almost on a consent order.
No.
Almost a consent order. Mr. Singh was here, my lord, I was here. It was almost on a consent order. The process is on. 50% of the process is over. Now, today, my lord, they filed an application and saying that the inspection can't go on. If I cannot, the special officer cannot stop it. No, my lord, special officer cannot stop it. No, lot of respect. There is an order of court, I understand. But special officer on its own cannot stop it. Just because a letter is given by Mr. Sen, my lord, the entire process cannot stop.
This matter was mentioned in the morning, and I have been informed that one application has been filed by the council. Council want to say that the order, the second order, suggests that it is a consented order. However, they want the court to clarify this, that they have no consent.
There is no
They have
question
not
of
consent, and court direct inspection. Okay, court direct.
Right now. I don't have a problem. Right now. But why would they stop it? I'll tell you, Lordship, why they would stop it. Because they've already found. Because it's already been found. Not at your convenience. What has
No. In the morning, I have stated that it was administration. This matter brought to my notice. That administration is now being forced to depute four staff. Administration is facing tremendous problem because we are shortage of staff, and to engage in respect of one matter, 4 staff, it is really difficult. So I suggested and proposed before them also, and what I want to narrate to you, both of you from your side engage 2 advocates each. They will act under the supervision of the special officer as well as the officer appointed by the London, and relieve the.
I
oppose this.
No, I bow down.
Continue.
Can he read first of all in the read petition? Documents have been preserved. That is fine.
But so I can't inspect them.
So why document has been preserved?
So grateful, man. So grateful. Because now the cat is out of the bag. The entire anomalies will not be found out.
Actually, okay, Mr. Sen, I have understood what is the agony of the council. Yeah, Mr. Sen, the court has taken the possession or custody of the ballot paper. So why?
So that the council office. I can't see them.
What is the allegation made in the writ petition? There is a irregularity or illegality in conducting the
Fact-finding inquiry is done. It's done here. It's done only in High Court. Yes, it's done here. And there is only one precedent in court number 17. And the order has been set aside. And what happens is yes. Now what happens is the report of the special officer has pointed out the anomalies. He cannot. He has. And now since it is coming out even more.
Okay, if you argue both at the same time, it is not possible for anyone to.
Already 430.
Now, how many ballot papers is there? It was not mentioned. Yeah, now it is appearing 65,000.
Yes, because 7 more days, it will be over. It will be over.
Initially, they have said that one inspection concluded.
From all over West Bengal.
But 65,000.
50% is done.
It has at the time of passing this order, taking such permission, that has not been brought to the notice of the court.
It was
65,000.
Milord, if I will show your lordship, Milord, from whatever already is there on record, your lordship will find an opinion, rather will form an opinion that what are the anomalies that we had, Milord. So your lordship will find, Milord, the amount of anomalies that's already there. The more it comes out, Milord, the more your lordship will see, Milord, how the election.
There is no requirement. If you even after examination of or inspection of 1,000 ballot paper, you can show that this was the anomaly. So there is no requirement to show that this anomaly is also exists in respect of 65,000.
Can you give us 7 days time? In the meantime, how many ever we are able to
yes. If we confine your allegation or your case that we could have inspected the up to the 2,000 ballot paper.
I have understood. I bow down.
And even upon inspection, we find that there is a illegal.
I bow down. Gives us 7 days
So it will lead any prudent man to presume. I am not. It should. Because High Court is facing simultaneously. So, Mr. Special Officer, London Special, so how inspection of how many ballot papers have been concluded as on date?
I am requested, but I could.
Daily inspection, High Court administration is also facing difficulty. The learned advocate, Mr. Chatterjee now is saying, but his junior also will face difficulty because you also face difficulty giving time to particular case. Mr. Chatterjee has many matters. Mr. Sen and Chatterjee, junior also go. Yes.
If you are once, I can go. There is no problem. I have no problem. I can also.
And I shall be forced to disengage the staff.
Gives us
engage by the
7 days time. Jotota hobe na hobe na hobe.
I said this. Let it not be consecutive.
Whatever they want, let them take. But
তো
no, you
7
can-
দিনের মধ্যে শেষ
why-
করে দিলে কি অসুবিধে হলো?
Your lordship has made it the matter reasonable on 6th August. They have sufficient time.
Very well.
No requirement that every day from 11 o'clock to 4 o'clock this will go on.
So, Mr. Sen, Mr. Sen, I am fixing 7 days. That means from 7 days. Okay. So okay. I am fixing 24 তারিখ তো সমস্যা হয়ে যাবে। So I am fixing it on 25th. It is a original side matter.
No,
Appellate side matter. So I am fixing it on 25th. Whatever inspection will be concluded. It is, I am not passing any order. I am fixing the hearing of the application. In the meantime, you use the affidavit to that application. Extend.
I don't want, because the special officer will not give any more adjournments, my lord, on the prayer of them. From tomorrow till 25th, whatever I will. Very well, let them not participate. Let them not participate.
No, Mr. Sen, one thing, rightly or wrongly, this permission has been granted. Rightly or wrongly. None of you has assailed this order.
I am not bound.
Now, none of you assail is there. So this order in force.
No, let them not participate.
Now, in this way, any party to the proceedings cannot say that I shall not obey this order. Yeah.
Then why are you sending letters, say, asking for adjournment? Don't send.
So peaceful solution is always expected. So I am fixing a date for hearing of your application, and since they are saying, and special officer is there, I am giving 7 days, and I have expressed my mind that don't try to multiply. Don't try to multiply. You will say that up to such thing, we inspected such numbers of ballot papers. From this ballot paper, we have located or got such irregularity.
This is a procedure for inspection which your lordship is devising. My respectful submission is the party will inspect. Whatever he wants to make note, he will make his own notes. Special officer will have nothing in the matter of preparation of anything.
It's in the presence of the special officer.
But special officer cannot act as
This is a time of final hearing. If he wants to make this submission, he can.
I have been put question.
At the time of final hearing.
Special officer has been appointed by the court.
Presentation of the court.
So he is representative of the court.
Yes. So he does not have the authority to tell the lordship.
I think I have trust and faith in him.
Yes.
Confidence in him, and he will maintain his impartiality, and what is required to be done, it will be done by him.
That is what I am trying to say. Special officer.
But where it is pinching is.
Yes, he is not the. Yes.
He's only saying whatever he's seeing.
He cannot say that. We cannot.
He is not a judge.
But there is no substance.
So this is actually unfair on Mr. Sen. This is casting an aspersion, my lord, on the special officer.
Oh, okay. If they want to bring any allegation, they must come with
an affidavit.
With an affidavit.
What is the purpose of the order inspection in the presence of the special officer? So order does not say that whatever observations the petitioner will notice, that has to be recorded by the special officer.
If he has an objection with respect to the report, he has to file that.
It would be petitioner's observation. You will. I think he has a learned advocate.
Yes, that's the report. That's what he's done.
What he will record, it is not his determination, not his conclusion. Conclusion and determination, I think it is leave to the jurisdiction of this court. What you will record, I think it would not be here. Mr. Sen's client has said, advise him to say so. And yes.
Again, kindly say the inspection by the party. There is the question of the court through special officer recording the observation of the petitioner.
His observations as well. Kindly have a look at the report once. Have a look at it. Aajke report. Have a look at it.
Okay. At the time of final hearing, you will say that it has not been properly inspected.
Yes, he can say.
You will
Let him say whatever he wants to.
Kindly comes back process of inspection.
I don't know why the council is so interested. That no matter is it, I shall not allow to inspect anyone. I think council is a impartial body. Council stand would be, you check what I have done correctly, impartially and lawfully. Lawfully. That should be the stand of the council. It's unclear to the court that what council is so interested to prevent them from making any
registrar. My lord, the registrar of the council.
Council is a body.
The registrar of the council, represented by Mr. Sen, had to be physically removed by this honorable court. He had retired 6 years back. He did not demit office, and that human being now is the advisor to the council, still holding on to his post.
But again, I repeat what I am
I will show your lordship, my lord, this election could not have been even conducted by him.
Let us not go into the matter. We are not arguing the matter.
Tumi to coach.
I am still on the aspect of scope of inspection. Inspection in a suit. When we ask for inspection of documents, interruption.
Okay, I am fixing in that. You stated that let them do within 7 days whatever they want to do.
I will not be called upon to make any comment. That is the one important. No special officer
Let them not participate. It is their choice. They don't want to participate.
So, Mr. Okay, I have understood. You are thinking that since special officer is recording their claim is getting a recognition. It is your claim. But if their claim is not recorded, then there shall not be any value. They would be just see and come.
It is for the
and Mr. Special Officer, I think as we record the submission of the parties in this way, you write. Yes, indeed. That the person who has been deputed to inspect on behalf of the petitioner claims such and such or state such and such.
That's exactly what is done.
Exactly.
What
Okay. Okay. You are giving pain to the court, confining the judge up to 440. Yes.
all parties' statement has been recorded.
Yes. Mr. Sen, don't think that the determination or order will be passed based on it.
Yes.
Court must apply its mind. Court must try to whether this observation is correct or not, or whether this observation can be based to pass any order or to cancel the election or not. Okay? Election or not.
Yes.
It's not possible
Yes.
for us to attend every day.
Do not attend. Do not attend.
No. Don't hear. Don't hear. Unless the court modifies this order, or unless the court is modified this order, and unless the court is set aside by the superior court, it is the duty of all to comply with that. You comply. If we find any difficulty to comply with the order, you come with an application. Court must. Yes. So, as you have stated that, let them do 7 days. They have also agreed. So I am fixing it on 25th July. Very good.
Yes, the lordship has made that clear.
24th, I have fixed many matter, original side, appellate side. Actually, since you are here, Mr. Chatterjee here, and such, I am giving 25. Because I have already booked, your all learned friend has booked up to 8 August.
Then our matter is already fixed on 6th August, let it remain on that day.
No problem, I have no problem. And the inspection should be finished by that time.
No, it is not. I am fixing it on 25.
The 25, I have some.
And I shall fix, though I shall not be able. So I am 28. Come on, 28.
And the inspection is.
I am not modifying this order.
Yes. Kindly hear this, Mr. Rai. My lord is not modifying. আরে ফাইলই নেই রেকর্ড করবে কোথায় আজব কথা
আচ্ছা দিয়ে দেবেন সময় টাইম হ্যাঁ
হ্যাঁ
28 28 দেখি 28 ওপরের দিকে দিয়ে দেবেন
6 তারিখ তো ছিল, it was there only on 7th. Why your lordship is preponing?
Milord, the inspection.
Since you have filed an application.
This application is only for
what?
My application, যে কোনো ব্যাপারে হওয়ার ইমিডিয়েট।
Yes, so I am not. Huh? Why? So Mr. Sen, who has filed application, he does not want to get the matter preponed. So I also.
Want the main petition to prepare. Let the application be heard.
Application along with application in connection with the petition. Okay, so other matter on which date?
Any day, my lord.
No, the matter has already 6th August.
7th August.
7th August.
So come on, send that will be proper.
I want the application because then my concept can be expunged.
That can go. I don't have a problem.
That is what I say.
Okay, it would be recorded. It would be remain here. Okay, so that you cannot put in embarrassing situation. It would be here.
The inspection
court will take responsibility.
Very good.
Okay,
and the inspection will go on, Milord. Kindly, Milord.
Yes, I am not modifying this order.
But kindly also record every day from 2 p.m. to 4 p.m. it is not possible.
You adjust.
And I have said, they don't want to enter what can be done.
It is between me and Mr. Sen.
Every day 2 p.m. to 4 p.m.
ঠিক আছে একদিন অন্তর হবে তোমার
Okay. Rest part is in the bar. Okay.